hello, everyone. You guys are up in here. Aren't you guys up in here? Hey, Tatum. Hey, Lady Red. Hey, Unpopular. Hey, Pretty Brown Eyes. Hey, Impressed Fox. Hello, and hello. Who else is in here? Who else is in here? Who else is in the house? Hey, Miles of Smiles. Hello. Let's see who else. Let's see. Brooklyn T. Hey, Breezy. Hey, Marley. Hey, who else is in here? Who else is in here? Hey, Thomas Style. Hey, Blessed One. Hey, Lee King 654. Hello, Shady. Hello, Blessed One again. All right, I'm trying to get everybody. Hey, Darlene. Hey, Pamela. Hey, Kaylon. Hello, everybody. Okay, it's everybody. J Towns in the house. Sandra. Hello. Who else? I just talking and talking and talking. Hello, everybody. I can't get everybody. I'm sorry if I missed you. Please forgive me. Hey, Quentin, Miss Melissa. Nona's in the house. Hey, Slick. Hey, everybody. Okay, if I did not call your name, please, please, please forgive me. I am trying to stay focused. Thank you, Yvette, for the Cash App. Thank you so much. Thank you so much. Thank you for it. I appreciate you so much. Shout out to all the wonderful people that was in the chat, guys. Thank you for my likes and my what do you call it? The emojis, guys. We got over 1,100 likes today. Shout out to you guys. You guys are the bomb. The bomb. And just, I'm just running my mouth because folks are coming up in here. And when they come in here, it seems like I have to repeat myself. And you guys hate it when I repeat. Because you'd be like, come on, Sylvia, could you get with it? Well, Goldie, you guys, we got a lot to talk about. We're going to start off with the day. I'm telling you, we can't even breathe. By the time you get in there, it's time to go in. You know what I'm saying? You know how we used to play around before when we go in? No. As soon as you go in, we got to get up, get the stuff rolling, and get out that room. That's the way it is now these days. Salute to you, Ben. We got to get out. You know what I'm saying? So, well, okay, my question is, guys, Weezy said, focus, Miss Sylvia, focus. Okay. What do you guys think about Judge Whitaker? What is do you like, if you put a 1 if you like her, put a 2 if you don't like her. Put a 1 if you like her, put a 2 if you don't like her. Lacey, you think she's Miss Glanville? Come on now, Lacey, you got to be fair now. Come on now, Lacey. Lacey is just so hard. I know Talk Glass is hard on her too. But come on, y'all. Y'all got to come on now. She gave y'all some little nuggets now. Come on. Y'all can't be unfair to her now. We'll put a 3. You know what? Somebody put a 0. What is wrong with y'all? -1. Y'all getting on my nerve for real. Oh my God. Okay. Here's a better question. Do you think she's a fair judge? Do you think she's a fair judge? We ain't talking about her giggling. We ain't talking about none of that. We're talking about, do you think she's a fair judge? Do you think she could see through the crap that the state's been doing? Yeah, did she just tell that? We're gonna go over some of the stuff that she did today, y'all. She went in on Adrian Love. She went in, y'all. She said, I have already made my ruling. You can keep on looking, but I ain't gonna change my mind, basically. That's what she said. You can keep on looking. And I think she laughed because she just don't want to embarrass them. Thank you, my Take TV. Thank you for the super chat. I think she just don't want to embarrass the lady, so she just go ahead on just appease her a little bit. You know what I'm saying? But let me tell you what happened, y'all. Let me tell you something's going on. Something's going on. Okay, let me tell you what happened. Okay. You guys know the judge was talking about KC. I'm gonna keep calling him KC. That's the way they were calling him before. So I'm gonna say KC. Okay. You know, the judge was talking about KC being in the about him wanting him to come in to see where he stand as far as his attorney and as far as whether or not he's going to testify and all that kind of stuff, right? So somebody in the chat said that he was out in that area, right? Someone said he was out in the area. So to make a long story short, I went outside and I happened to see him out there, right? And because you guys told me, Miss Sylvia, go out there. Y'all just be telling me what to do. I'm just telling you, y'all just be cracking that whip on me and just telling me what to do, right? So I went outside and I said, the judge was talking about you. That's what I said. I said, the judge was talking about you. And so he said he know because he was looking inside my chat. He said he was looking inside the chat. So so to make a long story short, he ended up coming in. So when he came in, the investigators in them stopped him at the door, right? They stopped him at the door and they pulled him to the back. And so when they pulled him to the back, the guy went and talked to the Atkins. He went and talked to Atkins, right? You know, the investigator with the little goatee beard. So how Woody pulled up? Because Woody was watching my live. He was watching my live. Because somebody said he was in my live. He was watching my live. That's how come he knew what was going on. So can I finish my story, please? Thank you, Breezy. Breezy said, focus. Thank you. Because Breezy, they're asking me questions. Breezy, tell them to leave me alone. I do, KK, you know I get distracted. You know, okay? Because I was at the light. That's why I was looking anyway. But listen, let me finish, y'all. Let me finish saying what I was going to say. So they had him to stay outside the door thing, right? And so I guess Harvey saw him out in the hallway. So Harvey came in because he was about to walk out. He came in and then he whispered into Steele's ear, and then he went over and told Shard, and he told Miss Westmoreland and told them, right? And then Deputy Ingram, the investigator told Deputy, no, he originally told the investigator originally told Akin, but Akin didn't move or anything on it because Love was on the podium talking. So when Love was on the podium talking, Akin just kept that information to himself. But Deputy Ingram found out, and so he contacted the judge. He went up and told the judge. And when he told the judge, that's when the judge said, that's why the judge said that that I've got word that Mr. Copeland is here, and so she called him up so she can ask him the question about if he had attorney representing him, and if not, then that's when she told him that he talked to his attorney, and then they had to reach out to Melnick, and Melnick ended up being on the Zoom, right? But they would, I don't know why they didn't Love didn't want him to speak at the time. I don't know what was that all about, but he ended up talking. So, and then he came back at 2:00 on the dot, y'all. He was back out there in the hallway. And Melnick had already talked to him on the phone, based on what Melnick was saying on the podium. So they were really trying not to let him in. So that is what happened in the courtroom, because they were really, I don't know. And did y'all hear what he said? Did you hear what he said? He basically verified what was being said, what Steele said. He basically verified that. He said something about, they said if he said go and say if he killed Nut, they're going to whatever. You heard that, right? But Pam, it's on record now. It's on record. Pamela, it's on record. Regardless of what, that court reporter took that. Even though if the judge just tried to dismiss it, the court reporter took it. Just like how we didn't hear the ex parte request by Love at the end, but when they went to play it again, they heard it. Just like if it has to go to the appeals court, they're gonna hear that transcript. It's in the transcript, y'all. In the transcript, regardless of what, it's in the transcript. It's in there, and I hope Steele's motion will say that he did say it on the stand just now. He could replay it on the live. They could replay it, and replay it. We heard it. Okay, regardless of what, we heard it, right, Miss Jam? We heard it. No matter how insignificant we might think it is, we heard it. Please slow the ad. Why y'all messing with my ad? That's how I get paid. Hello? I told YouTube make it aggressive. I said I type aggressive, moderate. They have conservative, and they have aggressive. I hit that aggressive. Too much Brady, and this judge know that instead she want to keep the circus going for the guy. No, she want to make sure that the record is perfect for her, because it goes against her. Because now if it goes back to appeals, and it's going to go against her, she want to make sure that her record is perfect from the time she took the case. And she want to make sure that what she has is correct. You know what I'm saying? And I was telling you guys earlier during lunchtime that from what my understanding, from what I am being told, is that that this case is not going to go that far at all. It's going to end before the time frame that claim is going to go into you. She remember she said between up to February or March. No, it's not going to go there. It's not going to go there. It's not going to go there. It is not going to go there. Who killed Nut? I don't know. I don't know who killed Nut. I wasn't there. I don't know who killed Nut. I don't know. I do not have a clue who killed Nut. Hey, Marcy. Yeah, I can't tell you who killed Nut because I don't know. I think the defense knows what she is doing, hence the reason why. If you notice, you see how Steele revisited the motion again. I think they're gonna keep beating it until something happens. So y'all think Woody is going to plead the fifth? Do you guys think he's gonna plead the fifth? Who think he's gonna plead the fifth? Or do you guys think that he is going to go ahead and get on the stand and tell them all kinds of craziness? What do y'all think? You said if he's smart, you said, yep. Somebody said, I think he will. I don't recall. You know, if he say I don't recall throughout the whole thing, I mean, you can't say he's lying because if he don't remember, he don't remember. How you gonna say? Because look at how many times what's the name said I don't recall, and then he also told the judge everything he said before was a lie, and even the judge said he was incredible. The judge even said he was incredible. Yeah, come on. If the judge is saying that he was incredible, then you don't know what's the truth. And so how you gonna hold him in contempt for telling something that no, he's not gonna be held in contempt? How you gonna say he's a lie? What, you gonna have to prove some paperwork, and there's no paperwork to prove anything. The only thing you got is somebody saying something. You don't have no proof. You have no weapon or nothing. You just have somebody's word. I would go up there and I wouldn't recall anything, y'all. I wouldn't recall anything. I wouldn't remember nothing. I wouldn't recall anything. That's me. Because I don't remember anything anyway. I for real don't remember stuff. People have to play the recording for me. And I still don't remember, man. I still don't remember. Who's getting frustrated with Steele, y'all? So you guys seen I have pictures of Mariah. She was in the court today. She was in the courtroom. And of course you guys heard earlier that young Scooter was in the courtroom. And I didn't even know he was related to Young Thug, to Jeffrey. I didn't know he was related to Jeffrey. I'll tell you how I found out he was related, right? Yeah, Chard was hated by Glanville. Now, I mean, this judge love it because he's prepared. He's always have information. He's like one of those nerdy kids in class. He got everything. You know what I'm saying? And he comes up and he speaks for the group. Still, y'all, still is at the point. He smiled a lot today, y'all. He really smiled a lot. Still smiled a lot today. Yeah, he really smiled a lot today. They did a huddle in the hallway today after KC left. They did a huddle. They did a huddle. They're gonna see that he's not a credible witness. So, regardless of what, the jury's gonna see he's not a credible. I would make myself uncredible as possible. The most uncredible witness they ever had on that stand. I would. Okay, yeah, I made it home. I made it home. Okay, I'm about to connect to my I think Mariah and family is gonna be there every day because he's coming home soon and they want to be ready. Yep, I agree with you on that one, Gemini. The judge, the judge, and you know the judge said it, y'all. The judge said that he is not credible at all. Thank you, Stephanie. Thank you so much. If Woody gets locked up for pleading the fifth, he will get out and declare. And if probably because they don't have enough evidence, they don't have enough stuff. If he plead the fifth, they ain't got enough stuff. And look, the case is gonna be over before till February anyway. Now it's up to him whether or not he wants jail food. If he wants jail food. I bet you his commissary will be full. People be calling him. He'll have so many people visiting him. So I don't think he'd be worried about anything. And he would be considered high profile. They have to protect him in jail too. Don't you think so? Hold on, I'm getting my mail and stuff. Hold on a second, y'all. Guys, I know y'all not trying to cheat me today. We have only 200 and something likes in my chat. And it's a whole bunch of you guys up in here. A whole bunch of you. It's over 1,001 and 8 people up in here. Okay. I'm gonna go show you some pictures that I took. And then I'm gonna show you some videos from being inside and don't talk about my sound, okay? This is only for visual. This is not for sound. So I'm gonna show you guys that. And then we're gonna read Steele's motion that he submitted. I can go into details about the feel of the courtroom, what people was doing and things like that. So I need you guys to hit that like button. I just walked inside the house because you guys asked me to come on. I came on early for you. The least you could do is be nice. Hit the like button. Do me that justice because I'm working hard for y'all. I work hard for y'all, okay? Y'all could do that for me. Can't y'all? And I'm gonna do the picture because I took lots of pictures with Mariah today. I took a lot of pictures with Mariah. Just hold on a second. Trying to get myself situated here. Okay, hold on. You're not black. Huh? Somebody said you're not black. What? You're not black if you don't hit the like button. you know. No, you didn't say that. Did he just say you're not black if you hit the like button? Says you want likes. We want less ads. Seriously though. Oh God. You want less ads? You need to go ahead and get a premium with YouTube. YouTube is the one that's getting the ads. Yeah, she's his girlfriend. Yes. She is Young Thug's girlfriend. Yep. That's his girlfriend. Hold on, yeah, I'm gonna get to my desk. Hold on. I'm logging on to my computer at my desk. Hold on. Okay, guys, sorry about that. I had to transition to over here. Here we go. Hey, guys. 30 days. I thought it's seconds. What do you mean 30 days? What are you talking about? Oh, we got people acting crazy on this live today. Oh Lord. You guys got my mods working today, huh? Mods working. Okay. All right, you guys, we're going to go ahead and play some of this stuff from this morning. And I can explain to you guys some stuff that was happening in court. New phone. Dom Wong. Yes. Brady material. It's so much stuff. Oh, man, you digging me? Y'all the best hall monitor on this side of heaven. Y'all the best hall monitor on this side of heaven. Y'all, shout out to my hall monitors, my mods. They call it... My mods are the greatest hall monitors ever. We got to throw them a party. Yes. Okay, is my girl here yet? She said she was gonna read for me. Hold on. My girl here yet? Is my girl here yet? Oh my God, what's... Okay, I can't open up my email. Let's see. Hold on a second. Let me go get her. Yeah, y'all bullied me to come on before 7:30. Yes, y'all did. It was Antonio. Antonio bullied me. Yes, he did. He bullied me. Where's my girl at? Where's she at? I'm gonna put the link in so you can come in, hon. She I sent her the link. I mean the motion earlier. I sent it to her earlier. Serena, come on, Serena. You in here? You here, Serena? Serena, come on, Serena. Yeah, Antonio said he had to go to bed, so we had to get on here live early. So this is all because of Antonio. Antonio got us up in here. Kai, David. Hey, Kai. Hit the wrong thing, huh? William, thank you. Another 5, Miss Sylvia. Is the bomb. You said you knew, but couldn't drop yet. Obviously not looking for what it is unless it's already happened. I told you. I told you I cannot tell you stuff yet. I can't tell you stuff yet. I couldn't tell y'all stuff yet. I couldn't. That's a cute water. It's cute. Y'all. Shout out to my I'm sorry, y'all. Dallas is just bringing me my food that she went. Shout out to Dr. TTA. She got my dinner. Gas money. No, I'm just playing. Dallas getting. Tell her to send me the gas money too, y'all. Yeah, she getting on my nerve. Dallas is getting on my nerve, y'all. Y'all see, because I wanted to get on here. Y'all want to see the plate? I want to see the food. Look, y'all. We got it from like this place called Horatio's. Ooh. They say, hey, Dallas. Okay. All right, let me go ahead on. Where's Serena? Where are you at? Everybody keeps saying, hey, Dallas. Everybody say, hey, Dallas. Hey, Dallas. Hey, Dallas. Come over here and say hi to these people. Send me gas money for me going to get the food. Everybody say, hey, Dallas. Tell her I need to be reimbursed for gas for getting the food. Tell her. Hashtag reimburse Dallas the gas money. I'm just joking. Y'all. You know she ain't joking. Right? The next minute they're gonna be like, oh, even the child begging. That's what they said. The last time when I bought food for her, they're like, oh, we feeding Dallas too. Look, T-Girl said, give her money. Sylvia, I'm gonna give her money. I'm gonna give her money. I'm just joking, y'all. Oh, somebody said, Dallas, your smile is sunshine. Aww. She got my smile, y'all. Yeah. Somebody said hashtag reimburse Dallas.
You.
You see how somebody said you have the best mom ever.
I do.
She appreciates me. Okay, yeah, let's go. Dallas, you want to read for me?
No.
Don't you want to read for me?
Go downstairs.
Serena. She left. She left. They said, Dallas, can't you read the motion?
Oh, Lord.
Kobe, you staying by me? Kobe's staying by me, y'all. All right. Okay, hold on. Where's Serena? Where you at, Serena? So I can Serena. Yeah, she's been watching the trial. Yeah, she's my twin. Dallas is my twin. Dallas, I'm out. I played too much. Yeah, she ran out of here. Okay, y'all, let's go ahead on and read these motion. Oh my gosh, Dallas, Stephanie, you just said she sent you gas money on PayPal.
Oh my goodness.
Oh, she's so sweet. Dallas.
Thank you, y'all.
Yeah, Stephanie. There's only
Thank
one
you,
person.
Stephanie.
Only one person.
She said only one person.
It is only one person. You want me to lie? It was only one person.
Come on, they want somebody to read.
You want? Come on.
No. I'm about to go eat. I'm starving. Cobes. That chicken is so good, but I'm not gonna lie, they were a little bit salty. They went heavy on the salt today. But I had tasted it in the car.
All right. Y'all ready? They said Dallas, you cute. Oh, Sonia, don't lie to her.
Haters go hate.
Oh, do you dig me? Just put your Cash App in here.
Oh my goodness. You think of me is hilarious.
They want to know how much was the food. Oh Lord, y'all, that's good. No. Don't worry about it, y'all. Don't worry about it. She was just messing with y'all.
Yeah,
she was messing with me, really.
I was playing.
She was playing, y'all.
I was joking,
because then folks would be like, she begging.
Oh, they begging. We're not begging.
Can you read, please?
Oh, I don't want to read.
There she goes. There she goes. She don't want to read. Where is Serena? Come on, Serena. Could we read? Who else want to volunteer to read for me? Oh, you know what? I'm gonna let the thing read. That's what I'm gonna do. I'm gonna let the what's the name reader read. Okay, we're gonna let the reader read. Hold on. We're gonna let the reader read, so then we don't have to worry about it. We're gonna let the reader read. Hold on. We're gonna let the reader read. Hold on. We'll fix that. We're gonna fix that for real. Okay. This is the motion that's still filed today, and I'm going to let the reader read it for you guys, okay?
In the Superior Court of Fulton County, State of Georgia, Indictment No. 22 SC 183,572. V. Jeffrey Williams, Judge Whitaker, defendant. Additional motion to disqualify lawyers Love and Hilton. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this additional motion to disqualify lawyers Love and Hilton in the above referenced case. In support of this motion, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all crimes in the above referenced indictment. 2. This honorable court denied Mr. Williams' original motion to disqualify lawyers Love and Hilton on August 1, 2024, based upon Mr. Williams' assertion that he intends to call lawyers Love and Hilton as witnesses at trial. 3. Mr. Williams respectfully requests this honorable court to consider the ethical violations made by lawyers Love and Hilton in support of this motion to disqualify. See Ford Motor Company v. App. 348, 3, 745 SC, 2D 299, 2013. 4. The enormity of violations of candor with the court, candor with counsel, and the denial of in the Superior Court of Fulton County, State of Georgia, Indictment No. 22 SC 183,572. V. Jeffrey Williams, Judge Whitaker, defendant. Additional motion to disqualify lawyers Love and Hilton. Comes now Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this additional motion to disqualify lawyers Love and Hilton in the above referenced case. In support of this motion, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all crimes in the above referenced indictment.
Oh, why is this thing not doing right, y'all? It's not acting right. Okay, where my reader at? It's not acting right, y'all. It's not acting right. It's not acting right. Somebody, you digging me said there's a reader in the chat. Who's the reader? Who is the one that said they wanted to read? Who? Impress? Okay, hold on. Let me put the link in. Impress? Okay, come on. Hit the link and Impress. Send me an email so I can send you the motion. Serena, where are you? All right. Impress, did you send me your email so I could send it to you?
What is your email?
Sparks1565@gmail.com.
One moment, please. Okay, you said Sparks. Oh, wait, what's the rest?
1565@gmail.com.
Okay.
I know this person not coming up here with that name. I know you're not coming up here.
All right, email sent.
Okay. You're not coming up here with that name, sir. Whoever you are.
I'll see y'all in the chat. Y'all welcome.
Appreciate you. All right, there we go. I just sent it to you.
Yes, ma'am. I'm waiting for it to come.
Okay. Everybody say you have a great voice.
Oh, thank you guys. I'm sorry I'm not looking at the chat right now because I'm trying to make sure I get the email, but thank y'all. Okay, I got it. All right. Let me know when you're ready. Am I starting from the very top or just starting where it says additional motion to disqualify?
You can start from additional motion but disqualify.
Okay. Additional motion to disqualify lawyers Love and Hilton. Comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby files this additional motion to disqualify lawyers Love and Hilton in the above referenced case. In support of this motion, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all crimes in the above referenced indictment. 2. This honorable court denied Mr. Williams' original motion to disqualify lawyers Love and Hilton on August 1st, 2024, based upon Mr. Williams' assertion that he intends to call lawyers Love and Hilton as witness at trial. 3. Mr. Williams respectfully requests this honorable court to consider the ethical violations made by lawyers Love and Hilton in support of this motion to disqualify. See Ford Motor Code v. Young, 322, Georgia Appeals, 348, and the rest. The enormity of violations and candor with the court, candor with counsel, and the denial of ethical prosecutors on this case are too much to permit lawyers Love and Hilton to continue as lawyers in this litigation. The below is just a touch of the constant misconduct by lawyers Love and Hilton in this case. 1. Recently, lawyer filed a motion with the honorable court that undersigned counsel had a duty to provide work product. Lawyer Love knows that the same is untrue, and the cases that she cited in said motion did not support the propositions of law that she asserted in the motion. See motion to compel defendants' compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed, filed on July 26, 2024. This was the fourth time that Lori Love raised the same frivolous issue, attempting to hide Georgia law from this court that she was explained at the 3 prior hearings on the same exact issue. See YouTube's dated 8/28/2024, as well as July 30th, 2024. In paragraph, I don't know Roman numerals, so I don't know what that is. In paragraph XI of the state's ex parte motion for the order to compel testimony necessary to the public's interest, there is zero truth to the assertion that any defense meeting occurred with Mr. Copeland to impact Mr. Copeland's decision to invoke the Fifth Amendment or any other matter. No defense lawyer on this trial had any connection or involvement with Mr. Copeland on or around June 6, 2024. This is a knowing misstatement by Lori Love. Prior to opening statements, the former court ordered all parties to share Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin Monday, November 27, 2023, so that objections could be made prior to presentation of the opening statement. One moment. See YouTube dated November 15, 2023. As well. Okay. On Friday, November 24, 2023 at 4:58 p.m., Lori Love shared her supposed demonstrative aid. During opening statements at trial, Lori Love showed a completely different demonstrative aid in violation of the prior court's order. See YouTube dated November 27, 2023. There have been no consequences for Lori Love's intentional, unethical, and continued misconduct. During the same opening statement, Lori Love defied another pretrial former court order without first obtaining permission from the now recused court by introducing to the jury that undersigned counsel had represented another person charged in this case. See order dated November 17, 2023, granting Mr. Williams' motion on Lemmy number 23 attached here too. Specifically in her PowerPoint, Lori Love showed the jury that undersigned counsel represented co-indictee Blalock. See YouTube dated November 27, 2023. Lori Love accused undersigned counsel of knowingly and intelligently misrepresented to the jury that Mr. Bean was taken to Grady Hospital by police from the scene of his arrest on September 11, 2013. At a bench conference, Lori Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence as Mr. Bean never went to Grady Hospital on September 11, 2013. See YouTube dated March 4th, 2024. Lori Love's allegations against undersigned counsel to the prior court were proven beyond any doubt to be totally knowingly false. See YouTube dated March 14, 2024. Over Mr. Williams' objections when the state was attempting to introduce a January 26, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, Lori Love told the prior court that only Mr. Williams' voice could be heard on this video/audio except for one other voice saying "yeah" in the background. Undersigned counsel told the prior court that Lori Love was incorrect and that several persons' voices were audible on this social media posting. Lori Love falsely accused undersigned counsel of misrepresenting facts to the prior court. Of course, Lori Love was proven to be the person who was untruthful and was again falsely accusing undersigned counsel of wrongdoing. This pattern of This pattern of prosecutorial misconduct illustrates the enormity of unethical conduct of Lori Love in the state of Georgia in this case. See YouTube dated April 24th, 2024. On Thursday, June 6, 2024, as well as Friday, June 7, 2024, Lori Love falsely accused undersigned counsel of purposeful extracting and tampering with jail recordings of Mr. Copeland. Again, this was another knowing, malicious, false allegation by Lori Love as she continues her unethical conduct. See YouTube dated June 6, 2024, as well as YouTube dated June 7, 2024. On Monday, June 10, 2024, Lori Hilton, Lori Love, and the now recused trial court attempted to hide Brady evidence from Mr. Williams and the other accused that was obtained during the unlawful ex parte meeting with sworn witness Copeland and his counsel. Specifically, Mr. Copeland made statements that anything he says is a lie, that he committed all of the crimes in indictment and the like. These statements are impeachment of Mr. Copeland and are squarely with the concept of Brady versus Maryland. Moreover, Loris Hilton and Love, with the assistance of the now recused judge, told Mr. Copeland that he would not get in trouble if he lied under oath unless he told a bold-faced whopper of a lie, that he could not be prosecuted based upon some erroneous theory that the statute of limitations has run, and Mr. Copeland would have to remain in custody until all 28 co-indictees' cases resolve. This is all unethical conduct in order to intimidate and coerce Mr. Copeland to testify at trial. The above does not encapsulate the horror of working with Lori Love and Lori Hilton. Not to be able to trust the prosecution to provide the simplest and most basic fundamental fairness, such as honesty to the tribunal and honesty in all of the courtroom, must mandate that both lawyers Love and Hilton be disqualified from this case. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, ask the Honorable Court to grant the above relief.
Thank you so. Excuse me, I had the hiccups. Thank you so much, Empress, man.
You're welcome, Mama. Have a good rest of your day. I'm in the chat.
All right, honey. Thank you. Guys, what do you think? I'm going to play some of those clippings that he put in as part of the motion. Sorry, y'all. Because of Empress, I was able to wolf my food down. Thank you, Empress. See, because I love you guys, I wolf my food down for y'all. If I get indigestion and any kind of stuff like that, any kind of food, if I get indigestion, I'm gonna blame y'all. I'm gonna blame you guys. But all right, I had chicken, I had some rice and some broccoli. Horatio is a place that's called Horatio Food. Dallas went and picked it up for me. What is wrong with this person? Why they keep this Nigger? What is going on with this dude? You're not coming up here with that kind of name. What is going on with you? Why do you have that name up there? You need to delete that name before you come up on my panel. Get out, come on, go find some place to play with. Don't come in here with that Nigger. I just told you the name, Libra. Nigger. I am. I'm about to drink some right now. Gemini. All right, hold on. Let me just play the part that All right, let's play the first one. The first one from this. All right, let's go first one up here. This one is the first one. And he did, let's see, the timestamp. The timestamp for this one is first one is timestamp. Oh, hold on. Empress, got another one. Hold on. We got another one to read, Empress. Empress, hold on. I got another one. I forgot about this one. Hold on, Empress. I'm going to send it to you to your email. Okay, Empress, I just sent it to you. Did you get it?
Not yet.
Okay.
I will let you know as soon as it comes through.
Okay.
Yes, ma'am. I just got it. Give me 1 second.
All right. What is going on with this person? Why do they keep trying to come up here? Who is this person?
Okay. I will be ready when you are.
Oh, let me put it up. All right. I am ready.
Okay. Renewed motion for fair and constitutional trial and appropriate remedies for constitutional violations. This would be the state of Georgia versus Shannon Stillwell. Comes now, Mr. Shannon Stillwell, by and through undersigned counsel, and hereby files this renewal motion for fair and constitutional trial in the above styled case. In support of this motion, Mr. Stillwell shows as follows. These are the background facts. 1. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and substantive felonies. Mr. Stillwell is an innocent man. 2. Like all citizens, Mr. Stillwell is guaranteed a fair trial and due process by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. The 6th and 14th Amendments of the U.S. Constitution guarantee criminal defendants the right to a trial in front of a fair and impartial judge. Poole v. State. The Due Process Clause guarantees the defendant a trial free of prosecutorial misconduct. Whitmore v. State. Mr. Stillwell and his co-defendants have been in trial for approximately 19 months. Approximately 75 witnesses have testified so far. Mr. Stillwell has remained in jail for the duration of this trial. Judge Ural Glanville was the original trial judge in this case. Judge Glanville was recused from this case via an order signed by the Honorable Judge Krause on July 15, 2024. Mr. Stillwell's rights. The state is seeking a life without parole sentence for Mr. Stillwell if he is wrongly convicted. Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. Prosecutorial misconduct implicates a criminal defendant's due process rights when it renders a trial unfair and violates the defendant's rights to a fair trial. Whitmore v. State. Due process also requires that Mr. Stillwell receive a fair trial in front of a fair tribunal. Poole v. State. Sedural v. State. Judicial integrity is the state interest of the highest order because the power and prerogative of a court to resolve disputes rests upon the respect accorded by citizens to a court's judgments, which in turn depend on the issuing court's absolute probity. Mayor and Alderman of Savannah versus Baston and Cook. To the extent this trial has failed to meet these constitutional requirements in the past, Mr. Stillwell demands that this court take appropriate actions. Whilst Mr. Stillwell is confident that the court will endeavor to ensure him a fair trial moving forward from the current trial judge, this does not cure the constitutional errors and the resulting harm to Mr. Stillwell which has already occurred. Readily apparent examples of error, impropriety, prosecutorial misconduct, and judicial partiality. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. As detailed in depth in co-defendant Williams' July 10, 2024 motion for a fair trial, the prosecutors of this case have repeatedly failed to follow the orders of the court, have made specious allegations against defense counsel, and have lacked candor to the court. This case has been plagued by improper legal rulings, including but not limited to an overly liberal and unconstitutional application of OCGA 801. Defense counsel has routinely been cut off by a prior trial judge when arguing these matters, and rulings have been made with little or no analysis. This case has also been exceptional in the mistreatment of defendants and defense counsel. Examples include, but are not limited to, an incident which occurred on or about October 2nd, 2023, when Judge Glanville initiated a contempt hearing against undersigned counsel Max Shard, attorney for Mr. Stillwell. On this date, Judge Glanville sent deputies to find undersigned counsel during court's lunch break and summoned undersigned counsel to chambers. A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him some bull in court. While in chambers, undersigned counsel was advised that he should not deny the accusations, and it is all captured on video. When undersigned counsel refused to apologize for something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later in the day, Judge Glanville initiated a contempt hearing against undersigned counsel. Judge Glanville berated counsel and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. In the end, the attorney David Botts, who was seated within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such a statement. Of course, the video that captured the event was never produced and no apology was made. Judge Glanville has repeatedly demanded that certain defense counsels, including but not limited to undersigned counsel, Attorney Brian Steele and Attorney Carrington Matthews, to sit down in a terse and abrupt manner when overruling valid objections, all in front of the judge. These incidents have been too numerous to document individually. Judge Glanville has sustained specious and frivolous vagueness and facts not in evidence arguments from the state that has effectively cut off the defense's ability to conduct a thorough and sifting cross-examination. Just one example of this can be found by viewing undersigned counsel's attempts to effectively cross-examine Investigator Tyrone Dennis. Judge Glanville, on two different occasions, basically called Attorney Brian Steele unprofessional and unprepared in front of the sitting jury. When it was shown that Judge Glanville's comments were completely off base, Judge Glanville refused a defense request to issue an instruction that the jurors should disregard his comments about Attorney Steele. Judge Glanville has monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse through security cameras for no permissible purpose, without cause. The state has repeatedly demanded reciprocal discovery from the defense without any legal basis and has repeatedly misstated the law covering reciprocal discovery, all to obtain an unfair advantage from Judge Glanville. The state has gone so far as to contact non-attorney members of the defense team and demand that they provide certain items to the state without consulting with defense counsel first. These actions were taken without any legal basis and were attempts to unconstitutionally invade the attorney-client privilege and the duty of confidentiality of the defense. The state intentionally and erroneously accused Attorney Steele of tampering with and altering jail calls made by Kenneth Copeland, which were served in reciprocal discovery. Of course, these heavy accusations were entirely false and without merit. There were no consequences for making these wild, false claims. On June 10, 2024, Judge Glanville had an illegal contempt hearing against Attorney Brian Steele. Judge Glanville briefly incarcerated Mr. Steele and attempted to sentence him to 20 days in jail. Judge Glanville deprived Attorney Steele of due process and the assistance of counsel. The defense, after repeated requests, has finally provided with the state's June 7, 2024 ex parte motion for order to compel testimony necessary to public interest. This motion, submitted by elected District Attorney Fannie Willis and Chief Deputy District Attorney Adrian Love, hereinafter Love, contains, upon information and belief, a glaring misrepresentation. In paragraph XI of this motion, the states assert that after an encounter with defense team members, Copeland informed representatives of the District Attorney's office that he may attempt to plead the fifth in order to avoid testifying against members of YSL. The motion does not provide any information regarding the specifics of this alleged encounter or which defense team members were allegedly involved. Upon information and belief, after reaching out to defense counsels involved in the case, this information is completely false. Upon information and belief, no members of any defense team had any contact with Kenneth Copeland on or about June 6, 2024. It goes without saying, upon information and belief, no defense counsel or members of any defense team ever interacted with Kenneth Copeland in any way that would dissuade him from testifying. This false and disparaging information about defense counsel was provided to Judge Glanville in an ex parte motion. The June 10, 2024 ex parte meeting. Except as authorized by law or by rule, judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Uniform Superior Code Rule 4.1. Ex parte hearings are only authorized in the case of extraordinary matters, such as restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of any objection that may be properly registered. City of Pendergrass v. Skelton, 278. Citing Anderson v. Fulton National Bank, 146. Ex parte communications are presumed to have been in error. City of Pendergrass v. Skelton, 278. Citing to Arnall v. Arnall, 207. Additionally, the Georgia Code of Judicial Conduct, Rule 2.9, instructs judges to generally avert ex parte communications to assure fair hearings. Rule 2.9 generally permits ex parte communications, such as a narrow exception for scheduling, administration purposes, or emergencies that do not deal with substantive matters or issues or the merits, provided that The judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. And B, the judge makes provisions promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. Georgia Code of Judicial Conduct Rule 2.9. On June 10, 2024, while the defendants and defense attorneys were all in trial courtroom waiting for the court to start, Judge Glanville, Love, and/or Fulton County Deputy District Attorney Simone Hilton, hereinafter Hilton, as well as witness Kenneth Copeland, hereinafter Copeland, and his attorney Kayla Bumpus, hereinafter Bumpus, all met ex parte. Upon information of belief, this ex parte meeting was initiated by Love. Neither Copeland nor his attorney requested this meeting. In fact, neither Copeland nor Bumpus ever expressed any concerns which would have prompted anyone to consider such a meeting at all appropriate. While the state falsely characterizes this meeting as merely a discussion about Copeland's grant of immunity pursuant to OCGA 245507, the reality is that Copeland had already been granted derivative use immunity on June 7, 2024. There was nothing else for the parties to discuss regarding the grant of immunity. Copeland never requested to meet with the prosecutors and the trial judge to discuss these matters. Additionally, the ex parte communications were more about than Copeland's previously granted immunity. Judge Glanville and the prosecutors discussed Copeland's proposed testimony and provided legal advice, albeit incorrect legal advice, and strategy to Copeland. Throughout this process, Judge Glanville was clearly working in concert with the state and abandoned any semblance of impartiality. Neither Judge Glanville nor the state revealed that these ex parte communications had occurred to the defendants or defense counsel who were waiting for hours in the courtroom, completely oblivious to what was occurring behind closed doors. Judge Glanville's silence violated Georgia Code of Judicial Conduct 2.9A1B. The defense would likely not know of these communications and their substance if not for attorney Brian Steele, who learned of the meeting by happenstance and confronted the court, bringing sunlight to darkness. When attorney Steele inquired about the secret June 10, 2024 meeting, Judge Glanville immediately sought to hold attorney Brian Steele in contempt of court. Judge Glanville attempted to incarcerate attorney Steele for 20 days for refusing to reveal how he learned about these illegal ex parte communications. Judge Glanville had deputies take attorney Steele into custody and attempted to incarcerate attorney Steele without notice or legal counsel. As the existence of the ex parte meeting became known, Judge Glanville frustrated undersigned counsel's attempts to learn more about this meeting, including undersigned counsel's repeated requests for a transcript. Judge Glanville claimed that what occurred in this secret meeting in his chambers was privileged. This claim of privilege was without merit. Judge Glanville, it appears, instigated some sort of investigation into this incident. The focus of this investigation was not on the impropriety of the illegal meeting, but rather on how attorney Steele and other members of the defense learned about it. This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movement of attorney Steele and undersigned counsel through the courthouse on June 10, 2024. As public pressure mounted, a transcript of the meeting was eventually provided to the defense. The transcript of the meeting speaks for itself and is shocking. The transcript reveals that A, neither Love, Hilton, nor Judge Glanville had a legitimate basis to engage in ex parte communications. B, the ex parte meeting was not requested by Copeland or his attorney. C, the prosecutors, specifically Love, misrepresented facts and made specious allegations against attorney John Melnick, hereinafter Melnick, undersigned counsel, and attorney Steele to Judge Glanville. D, the prosecutors and Judge Glanville incorrectly advised Copeland about the law of derivative use, immunity, and applicable statute of limitations, all in an attempt to coerce Copeland to testify. E, the prosecutors and Judge Glanville incorrectly advised Copeland that he could be held in civil contempt indefinitely if he failed to testify, all in an attempt to coerce Mr. Copeland to testify. F, Judge Glanville abandoned any semblance of neutrality and worked in concert with the prosecution by advising Mr. Copeland and Copeland's attorney about legal matters, all to cause Copeland to testify. G, Judge Glanville assisted the prosecution in the preparation of Mr. Copeland as the state's witness, instructing that a list of questions prepared by the state be provided to him. H, a significant amount of Brady material poured out in this meeting, but the same was hidden from the defense. Neither the existence of this meeting nor this Brady material was revealed to the defense until the transcript was finally released. The June 7, 2024 ex parte meeting. On July 30th, 2024, the Honorable Judge Whitaker presided over substantive matters of this case for the first time. The Honorable Judge Whitaker provided much-needed clarity to the defense by releasing the rough draft of a transcript of additional ex parte communications between the prosecution and Judge Glanville. This ex parte meeting occurred on June 7, 2024, and included Love, Hilton, and Judge Glanville. These communications and the substance thereof had never been disclosed to the defense until the Honorable George Whitaker released the transcript. Neither Judge Glanville nor the state ever made any disclosures regarding these communications, even as Attorney Steele pulled the curtain on July 10, 2024. Instead, Judge Glanville and the state remained silent on the topic. Additionally, while the parties were well aware that the Honorable Judge Krause was considering the advisability and potential implication of June 10, 2017, as part of her consideration of motions filed to recuse Judge Glanville, upon information and belief, neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was in fact another ex parte meeting that had occurred 3 days prior. This was their secret. The transcript of the June 7, 2024 communications is shocking. It also sheds light on how this case has become irretrievably broken. As an initial matter, there is no stated justification for the ex parte communications. The meeting was initiated by the state. Neither Copeland nor his counsel had requested that the state meet in private with Judge Glanville. The meeting itself was illegal. The state, in this meeting, intentionally and wrongly attacked the character of Copeland's attorney, Melnick, claiming that Melnick was not representing Copeland's interest. The prosecutors besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors in a manner that they would have preferred. The prosecutors claimed to be the only ones who were truly representing the interest of our witness. The prosecutors complained that they had been having productive communications with Copeland outside the presence of Melnick before Melnick had, quote unquote, inserted himself in the client's legal affairs. The prosecutors claimed that Melnick was not representing Copeland's interest is rich. As they were communicating with the person behind Melnick's back, the state had intended to call Mr. Copeland as a witness without granting him any sort of legal protection as a witness. It was only after Melnick inserted himself and advocated for his client that the state sought to grant Copeland derivative use immunity. The irony does not end there. The state in this meeting claimed to be concerned about the possibility of Copeland suffering an unjust jail sentence due to Melnick's interference in his client affairs. At no time, however, did the state ever seek any non-custodial alternatives to Copeland should Judge Glanville hold him in contempt. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Melnick's devotion to his client, as Mr. Melnick was planning to leave the state on vacation while his client was incarcerated for contempt. The state complained to Judge Glanville that Melnick had not planned his vacation around Copeland's testimony. This is a ridiculous accusation, as the state intentionally failed to communicate with Melnick and had not given Melnick any notice that they were planning to call his client to testify on June 7, 2024. The state was clearly only concerned with Copeland's interests as long as they were directly aligned with their own interest. The state feigned interest in Copeland's well-being to get a foot in the door to Judge Glanville's chambers, all in an attempt to initiate improper ex parte communications. Melnick was not only the attorney who was disparaged by the state and Judge Glanville in the secret June 7, 2024 meeting. Love claimed that she was in receipt of the email from Melnick sent to her in Hilton, but also that other individuals had been, quote unquote, blind copied on the communication. The clear insinuation from the conversation is that Attorney Steele and undersigned counsel who were, quote unquote, blind copied. Undersigned counsel does not make blind accusations, but neither undersigned counsel nor Attorney Steele were blind copied on any email between Love and Melnick. Later in the ex parte meeting, Love again brings up Attorney Steele and undersigned counsel, noting that we were included on a June 6, 2024 email from Melnick. Love and Hilton were also included on this email, in which Melnick expressed his client's decision to exercise his Fifth Amendment rights if called to testify by the state. It is unknown why Love feels that she should have a monopoly on information or why she feels the defense attorney should not be included on discussions concerning these matters. Undersigned counsel would like to inquire about these matters with Love, sworn in as a witness. Judge Glanville abandons any partiality and echoes Love's thoughts, asking, why would he, Melnick, have done that giving? Before ADA Hilton responds, and that's the state's concern, Love then affirms, quote unquote, that's the point. Rough transcript, page 8. As Judge Glanville had questioned, so do I. The undersigned counsel asked why my inclusion on this simple email communication was of concern to the court. Love then assures Judge Glanville that she is looking for a remedy for this materially false and made-up situation, as if one exists, and tells Judge Glanville that she will contact him when she finds a solution, either over the weekend or on the coming Monday, presumably through additional ex parte communications. Before wrapping up the illegal and unethical meeting, Judge Glanville refers to quote-unquote outside agitators affecting the trial, stating, but I see it from just being in the courtroom and tracking. Judge Glanville's concern and inherent skepticism of email communication between Melnick, Attorney Steele, and undersigned counsel exemplifies Judge Glanville's bias and partiality towards the state. The transcripts of both the June 7, 2024 and June 10, 2024 ex parte meetings show Judge Glanville's clear bias against Attorney Steele and undersigned counsel, and finally provided an explanation, albeit an unacceptable one, for Judge Glanville's treatment of the defendants and their counsel throughout this trial. The illegality of the ex parte meeting now known to the defense. We now know that 2 ex parte meetings have occurred. These ex parte meetings were clearly illegal and improper. The state relies on King v. State 273, Georgia 258, 2000, in a specious attempt to argue that these ex parte meetings were proper. The state reliance on King is misplaced for several reasons. First, in King, the state met with the court to provide information that will allow the court to make a judicial determination as to whether the anticipated testimony of the witness was, quote unquote, necessary to the public interest under OCGA 245507, as is required under the law. In this case, Judge Glanville had already conveyed derivative use immunity to Copeland early on June 7, 2024, presumably in a third, albeit first in time, ex parte meeting. There is no indication that the witness was present for the meeting in King. While the actual forthcoming testimony expected of Copeland was openly discussed in Copeland's presence in the Star Chamber June 10, 2024 meeting. Second, in King, the defense was never alleged that they were not informed of the substance of the ex parte meeting in a timely manner. In our case, purposely hid this illegal and unethical conference from the defense. The fact that these meetings occurred, much less their substance, was only revealed due to the dodginess of the defense and sheer happenstance. Third, while the subject matter was limited to the quote-unquote necessary to the public interest requirement of OCGA 24507, in King, the subject matter of the June 7th and June 10th ex parte meetings included much more, including specious and knowingly false allegations made against defense counsel, and by relations the defense themselves. These improper ex parte meetings are the result of both grave prosecutorial and judicial misconduct. These meetings were never requested by Copeland, Bumpus, or Melnick. Instead, they were all initiated by the state and welcomed by Judge Glanville. These meetings, when considered with other previous discussed actions of prosecutors and Judge Glanville in this case, violated Mr. Stilwell's constitutional rights to due process and a fair trial. These meetings, especially when considered in addition to Judge Glanville's other actions throughout this trial, have also violated Mr. Stilwell's right to a fair trial in front of an impartial judge. The transcripts of these meetings reveal that Judge Glanville, perhaps based on an inaccurate and misleading information provided to him by the prosecutors through ex parte communications, always looked at Attorney Steele and undersigned counsel, as well as our respective clients, with suspicion. Judge Glanville, in meeting with, consulting with, working with, and planning with the prosecutors, clearly abandoned any semblance of impartiality. Both of these meetings occurred during critical stages in this trial. Mr. Stilwell had a constitutional right to be present. See Article 1, Section 1, Paragraph X11, it's Roman noodle, of the Georgia Constitution and the corresponding section of the United States Constitution. Scudder v. State, 298, Georgia 438, 440. As Mr. Stilwell nor his counsel were permitted to attend these meetings, Mr. Stilwell's 6th and 14th Amendment rights of the United States Constitution, as well as Article 1, Section 1, Paragraph X11 of the Georgia Constitution, were violated. This is a structural error which will demand reversal should Mr. Stilwell be wrongly convicted of any count in this indictment. The remedies. Mr. Stilwell has been harmed by judicial misconduct, prosecutorial misconduct, and other error in this case. Focusing solely on the ex parte communications, the prosecutors and the trial judge teamed up to coerce and intimidate Copeland to change his mind and testify for the state. Copeland's testimony was harmful in itself, but does more than that. As a result of this coercion and intimidation, the state has and plans to continue to impeach Copeland with his prior inconsistent statements, essentially playing several videos of Copeland's out-of-court statements, which are harmful and prejudicial to Mr. Stilwell and others. These out-of-court statements involve several of the charged events and counts in this indictment and are central to count 2 of this indictment, which alleges that Mr. Stilwell committed the murder of Donovan Thomas. Mr. Stilwell does not wish to demand a mistrial. Absent a finding of garroting, Mr. Stilwell, that's what it says. Mr. Stilwell does not wish to demand a mistrial, absent a finding of goading and thus jeopardy attaching. Mr. Stilwell has been incarcerated throughout the duration of this case. He has been viciously attacked while incarcerated. He almost lost his life. Starting trial all over again is not a viable option for Mr. Stilwell. Despite the persistent legal errors, the illegal actions taken by the prosecutors and the previous trial judge, and the damage inflicted by the presentation of Copeland's prior untruthful out-of-court statements, the defense is winning. Additionally, this trial is already tainted by structural errors. Mr. Stillwell does not wish to submit to the desires of the state and Judge Glanville, who have attempted to goad Mr. Stillwell into moving for a mistrial. Mr. Stillwell does not want this case to start all over. Nonetheless, serious errors have tainted this trial. It is unacceptable that Mr. Stillwell must accept that the first several months of his trial have been tainted by prosecutorial and judicial misconduct, illegal ex parte meetings, and partial judge. It is unacceptable that Copeland's out-of-court statements, which are arguably admissible as a result of previously discussed illegal ex parte meetings, may be played for the jury. It is also unacceptable that the previous rulings of a partial judge should continue to guide this case. Judge Glanville's hostility towards and suspicion of undersigned counsel has likely created a lasting impression on the jury, who surely view a trial judge as a person in authority. Carrying on with this trial as if nothing improper has occurred is not an acceptable option. The structural errors and other legal reversible errors in this case must be considered in the context of how they occurred. All of these errors have been caused by the prosecution and Judge Glanville. Neither Mr. Stillwell, undersigned counsel, nor any co-defendants or the counsel have caused or invited any of these issues. Hilton is a seasoned prosecutor of nearly 15 years who holds the title of Deputy District Attorney in the Fulton County District's office. Per the District Attorney's website, she helps lead the Special Victims Division. She has received many awards with the District Attorney's Office and has also taught trial techniques classes at Emory University School of Law. Love is an attorney with almost 20 years of litigation experience, almost exclusively as a prosecutor. Attorney Love is the Chief Deputy District Attorney of the High-Profile Cases and Difficult Witnesses Division within the Fulton County District Attorney's Office and is part of that office's executive team. She leads a division in the largest district attorney's office in the state, one that is dedicated to cases involving quote-unquote difficult witnesses. The Georgia Court of Appeals has noted that quote-unquote state prosecutors are generally knowledgeable and well-trained. Too knowledgeable and well-trained not to know the consequences of basic rules of prosecutorial procedure and conduct. Wilson v. State, 233, Georgia Appeals 327. Prosecutors as recognized and experienced as Hilton and Love should certainly be held to this minimal bar, if not much higher. Surely Hilton and Love, with their knowledge and experience, knew of the impropriety of these ex parte communications. Their experience told them something else, however. Based on their knowledge of the law, of impeachment, and prior inconsistent statements, the prosecutors knew that if Copeland did not testify and remained in jail, even a partial judge would be hard-pressed to allow the jurors to hear the multiple hours of Copeland's recorded statements. The ex parte meeting was a calculated risk for the prosecutors. Either Copeland would be intimidated and coerced into testifying, or the illegal ex parte communications would be grounds for a mistrial and the state would have time to regroup and begin anew. Judge Glanville currently serves as the Chief Judge in Fulton County Superior Court. Per the Fulton County Superior Court website, he has been a lawyer for 37 years and has served as judge for 29 years, 19 of which as Superior Court judge in Fulton County. Judge Glanville knows the rules concerning ex parte communications, both in the Uniform Rules of Superior Court and the Georgia Code of Judicial Conduct. Based on the experience of prosecutors Hilton and Love, as well as the experience of Judge Glanville, the notion that the decision to hold these repeated, secret, illegal, and unethical ex parte meetings were due to inexperience or simple lapses in judgment does not pass any test. These were conscious decisions to secretly violate the most basic of Mr. Stillwell's constitutional rights. Several factors in this case, including the prosecutors and trial judges' wealth of experience, the rigorousness of the prosecutorial and judicial misconduct, the facts that the evidence presented so far have been far from overwhelming, the structural and reversible error already baked into this case, and the repeated violations of these rules all clearly support a finding that their actions were intentional and designed to goad a mistrial. See generally State v. Jackson 306, Georgia 626, Anderson v. State 285, as well as Wilson v. State 233. Conclusion. This case is constitutionally and legally broken at this time. Mr. Stillwell is not requesting a mistrial absent a finding of goading, but appropriate remedies must exist. Possible remedies include, but are not limited to, disqualification of the prosecutors involved in this misconduct. Judge Glanville has already been recused. The dismissal of the indictment with prejudice, instructions to sitting jury that's explaining the situation in full candor, and or mistrial with the finding that a mistrial caused by judicial and prosecutorial misconduct and the defense was goaded into any such request. Wherefore, undersigned counsel respectfully request this court considers Mr. Stillwell's arguments and issue an order which will fully and adequately protect Mr. Stillwell's constitutional rights this second day of August 2024. Max Shard.
Thank you, Empress. Thank you.
You're welcome. My mouth dry as heck, but I'll do it any
I
day for
know.
you. Let
Get
me
some
know.
water. Thank you, dog. Get some water. Thank you. All right, guys. That was great. Great. That was some good stuff. What do you guys think? What do you guys think? Think. That was awesome. What do you guys think about this motion? What do you guys think? What is wrong with this person, y'all? Oh my God. Let me block him. I'm going to block this person from my channel. I just blocked them. They can't come up here no more, even if they try to hit it. I don't know who that person is. They keep putting craziness in there. All right. Why you said why she's still because okay. Did you not come to my live this morning? Did you not hear what I said? Did you not hear what I said? What are you laughing at, though? You laughing at me? Come to my live this morning. Because they don't listen. They don't listen. That they worse than you when you were little. Uh-oh. They don't listen. They don't listen. Hard-headed children. Killings. Hey, you blowing too much wind over here. It's cold. Sorry, I was blowing your friend. Okay, stop blowing. It's too cold. Funny. You let me do it. Look at my feet. Kobe. Dallas? Huh? You remember, you like the kids in the short bus. So you trying to call yourself a short bus? New Brady with the phone. There's a Dom, there's Brady, there's prosecutional misconduct. There's so much. Stop lumping all of us together, please. I said, stop lumping all of us together, guys. Let's go ahead on and review some of the stuff that still have put in here. You guys are hitting the like button. You're hitting the like button. You're hitting the those little emojis. All right. Okay. Here come John, y'all. John and Robert. Okay. We always have John and Robert. Let's see what John says. John says, no judge on the planet is going for Steele's, Weinstein, or any of these frivolous, unfounded motion. Oh my God, John, man, John, y'all, John. And I'm waiting for Robert to come in here. John and Robert, I can always count on those two, man. We're gonna make a believer out of John one day, y'all. We're gonna make a believer out of John. We're gonna make a believer out of John. Seriously, we're gonna make a believer out of John. He's still in here. Yeah, look what John said. John said, LOL, laugh now and I'll get the last laugh. This won't age well for you. Guys. Okay. Janelle said, I think the judge would be hesitant to grant a mistrial because this indictment involves her friend Glanville. Okay, Nick says, Sylvia, I got a request. Please. What's the request? You want me to put the link in there? Hold on. Let me put the link so you can come on up.
Don't be ghetto.
No, Nick is cool.
Because you know, you be having people come up there.
You know, they be trying to come up here because I'm gonna screen them before they start coming up here because this person keep typing in here. Some weirdo keep coming up in here.
I'll never forget that one time. You got a lot of somebody at the dating dog go there.
I hurry up and took it out. That's why.
That was crazy.
These people crazy. Go ahead, Okay, here come Nick. Hey, Nick.
Hey, Miss Sylvia. How you doing?
I'm good. How you doing, Nick?
We got another blessful day.
How cousin doing?
He doing real good. We all doing good. We'll be doing good once we get you on our team. Hey, but look, I got one request. Like, I've been working. Hey to the comment box.
What's the request? You must mute yourself, Nick. We don't hear you. Nick, we don't hear you. Good guys, do y'all hear Nick? Do y'all hear Nick? Nick, you gone. All right, Adam, show your face, Adam. Adam, show your face in order for me to let you out. Adam, show your face. I know Nick. I don't know you, Adam.
Okay, I'm back. You can hear me?
Uh-huh.
I don't mean to go back to it, but I need you to play that one part from yesterday when the investigator got up on there and he told all them tales. It was just the expressions he was doing with the hands, and he ain't know nothing.
Oh, you want me to play him?
Please, man. When I tell you, man, I was crying my life away. Them boys ready to come home. They'll be home before the end of the year. I hate to say the end of the year, but this judge, she's being the judge right now. And she's doing her job. It's just she's not focused on what the defense has to say.
She's on evidence and proof.
Yeah, and it's like they giving her the evidence and proof, but it's like she's accepting the he say she say from the state.
I don't think so.
So from your understanding, you think Love gonna get out of there?
I don't know.
You don't know. You looked off. I believe she getting out of there.
I don't know. No, I looked off because a dog is walking by here.
Oh, okay. Okay. Hey, little doggy.
Kobe. He said, hey.
Hey, Kobe. Yeah, I honestly think they'll be home. It's just she's just being a judge, and she know the world is watching. That's the main thing. She know the world is watching her right now, and she's trying to be the biggest judge she can. And also, she's trying to cover up for Fulton County.
Yeah, she worked for Fulton County, so
she's trying to cover up all the damage what Glanville and the state done did. That's the main thing.
Mm-hmm.
So I think they're gonna come home. Them boys coming home.
All right, you ready for it? We ready to play.
I'm ready to go on back down to the comment box. I gotta laugh. I ain't gonna be able to laugh on here.
Okay, all right. Yeah. Tall Glass said, "What's up, Dallas?" Hey. Yeah, we're getting some weirdos coming up in here. Here come Pastor. Hey, Pastor. Pastor. I need to see your face, Pastor. Because I've been getting weirdos. I gotta make sure it's you. Okay, there we go. I have to make sure it's my pastor because Pastor, those folks be coming up in here. They keep being weird on this chat.
Hey, Miss Sylvia, listen. This is about to be live.
Tracy's here too. Hold on.
Hey, Miss Sylvia, how you doing?
What's up,
good.
Tracy?
Chilling. Hold on, let me turn this TV down.
Miss Sylvia, I want to quit my job. I want to see if you can help me get into law school, Miss Sylvia, because today was funny to me. And today was funny. I just want to quit my job. I think I want to be a paralegal or a lawyer. You know, y'all don't get on me in the chat, but I think it's about to be my new job. Because you mean to tell me,
Yeah, can we listen to the part that was the name once first before we start talking, guys?
Okay.
I know y'all excited. We on early today, so let's listen to the part because Nick did ask a request.
One thing we can do that is not anything of substance but is important is I want everybody to speak into your mic and let's make sure each of them works all not at the same time, one at a time. And if there are any that don't work, I'm going to try to see if we can get a hold of one that does. So can we start with the state?
Yes, Sean.
All right. And I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards you some more. And I'm also going to try to get a longer neck on each of these.
Good afternoon.
All right. Yeah, you're just going to have to get it closer.
User error, I think, on my
part. User error. Okay.
Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work? Does that help at all? Did y'all? I don't know that
Is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great. Mr. Sharp.
Testing, Your Honor.
Great. And then who else is left? Misty Williams.
Good afternoon, Your Honor.
All right. Wonderful.
Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross check mics off my list. Okay, Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the Infinity and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes, ma'am.
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor. I do believe that there was more that she said that was disclosed other than just the Infinity.
Okay, what else?
Specifically when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. That actually came through more clearly than I think anything else, Your Honor.
Okay,
Your
so.
Honor, may I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
Hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer.
Okay, it
apologize.
happened.
I
Oh, your
silenced it.
computer? Okay.
I silenced it.
All right, thank you. So, Ms. Love.
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus with Donovan Thomas, but I can claim all of this.
Spoke, Miss Love is who I meant, but I think because Investigator Long has taken the
Okay.
stand, my mind may have been,
All right.
been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abate, my ruling with regard to that was that's not even relevant until such point as there might be some other defense motion filed, at which point Ms. Love can call Mr. Abate. So, okay, so call Investigator Long. Thank you.
Raise your hand. You swear firm testimony is the truth, the whole truth, nothing but the truth. First and last name for the court.
Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's not going to be testifying as an expert, so let's just, cut to the chase. To the extent he's not going to be testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Yes.
So maybe we don't need to go through all of his background. All right.
Just good afternoon, Deputy Chief Long. Would you tell the court for the record where it is that you work?
I work for the Fulton County District Attorney's Office.
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we're here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? As
Yes.
investigator? And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in line and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies, and with Kendra Copeland, and myself and Ms. Hilton.
Was I present in chambers at the time you arrived with Ms. Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Okay. Were you present with Ms. Hilton when was Ms. Bumpus in the room during the entire time that Ms. Hilton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hilton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Ms. Bumpus testified?
I was.
Did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hilton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Ms. Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there ever a time that you all went off the record at either attorney's request? That is either Ms. Bumpus or Ms. Hilton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Ms. Bumpus is talking about right before we went back on the record. There was a conversation where Ms. Hilton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Ms. Hilton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you being you and Ms. Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room.
Okay.
Except for Mr. Copeland and the deputies.
Okay. Did Ms. Hilton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No.
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, "I can claim all of this"?
No.
Were you and Ms. Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
Yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No.
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hilton, can you tell the court the topics that you discussed? That not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed?
The topic at that time, Ms. Hilton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hilton...
All right, hang, back up. So...
Hey, back up.
Is it your testimony that there was one brief off-the-record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe yes, no?
Yes, we broke for someone used the restroom.
Okay.
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to
No, she
get
was not in there.
clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in,
Okay.
and then Ms. Hilton did ask she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in
Mr.
time?
Copeland was in there.
All right, and so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would.
Seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
But you heard what he said.
She did mention the Donovan Thomas case, and that if you got and claim something that
He went and
he knows he
told.
didn't do,
See,
and
he
we
said it
have proof
before
that
he
he
said
didn't
they
do,
would have talked
then
about
she
it.
would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or we, or I'm going to prosecute you for perjury?
During the course of the conversation,
I mean, you said it twice.
Mr. Copeland's concern appeared to be his statements or inconsistent statements.
I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something, and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it in sense was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of line 11. I'm sorry, line 19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hilton says yes.
Okay.
And Ms. Hilton
Nick,
in line
this is
24,
very boring
page 50
to me.
says it's not what you're saying.
Nick, I'm gonna move forward on this because it's boring.
What you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place?
Aren't you bored of this?
Off the record?
I want to hear it.
Objection, lady.
Sustained.
Yeah.
Sustained.
I'm sorry, y'all. Do y'all want to hear this? This is a boring, Nick. Nick, this is very boring. I'd rather listen to Kenneth for today. That's what I want to hear. Infamous, you breaking up. No, okay. I was breaking up because I was on. No, Sylvia. I have a theory. What's your theory? Yeah. Who said yeah? Oh, hold on. What did it say here? Type of win. Nick, this is boring right now. Nick, this is really, really boring. He spilled the bean. He did spill the bean. He told. Because he matched what what's his name say? All right, let's go ahead on and do today's live. Because this stuff here is boring. Pastor, you ready to say something?
Yeah, just waiting on your command.
Go ahead, Pastor. Let me go get the other part.
So I think, I understand why Nick wanted that in there because I'm laughing. Like me and Tall Glass said, we're gonna need some therapy after this, Miss Sylvia. I'm thinking about changing my whole profession. Because you mean to tell me we can bring charges against the person, put some stuff on pieces of papers, and then we got to go through all this to see what's excluded and what gets to stay.
Mm-hmm.
Like this is, I'm happy I'm not a gangster. Listen, I'm happy I ain't a gangster or a rapper. Okay, because this is preposterous. All right, this is. I've never seen anything like this a day in my life, and I think that's where the mental portion comes from. I'm for real. I'm scared to even book a therapist appointment. I'm like, you want to talk about what? You want to talk about the thug trial? Because I mean, right is right and wrong is wrong. It's like I said, it's like I don't know. Like I said, oh boy, he snitched. But now they want to take all of Woody's testimony back and they want to restart it all over because they know it will be in favor of the defense. Okay? It will be in the favor of the defense. So y'all want to start Woody from square one. And now, I don't know. Because, see, I think this time we will see Love probably get at him. Not unless they waiting for Hilton to come back. I know him and Love got a strange relationship, but they gonna try to keep Woody. Now that they gotta restart him all over, they're gonna ask him the same questions all over again, and they hoping for the same performance. Okay, and then bam. Okay. Now the question is what are you gonna take one for the team? And this is not about the YSL team because I'm not saying they're part of YSL because Woody look like he is own man right now. Okay, from what I've been seeing, from what everybody else been seeing. All right.
You say he what?
He looks like he's his own man. It ain't nothing about no YSL. I done did it for Thug. I done did it for the guy. Listen, Woody is like his own man. Now the question is Woody prepared to, depending on what him and Melnick go up this week with, or is he ready for to be impeached? Or is he ready for them to frustrate him and then he's going to cop out and he's going to say, I don't recall? Because if I'm not mistaken, Miss Sylvie, even saying I don't recall, they still can impeach him when he gets up there and start talking about
how you can't impeach somebody because they don't remember, they don't recall. You can't impeach them.
But if they play the evidence, if they ask him a
question, that doesn't mean that you're gonna remember. Your mind, you could be on drugs and use a whole bunch of stuff and you can't remember crap.
Okay, I did not know that. So okay, that'll be Woody's the defense then. I will go to I don't recall route.
I'm just saying, you remember DK kept saying he used so much drug, his brain's fried. He don't remember that. You don't remember?
He did say that. Yeah. So that'll be Woody's. That'll be his defense right there. And I'm hoping that Woody is looking. Okay, I'm not a lawyer, but talking over with Melnick.
Well, I mean, in life, you're not going to remember everything, especially if you've had trauma and stuff like that. You're not remembering everything. Hey, Tasha, you're not going to remember everything in life. I can't remember stuff. I can't even remember what I ate this morning. So what are y'all talking about? You could forget, man.
Yeah. You listen, you're right, but I don't know. Like, I love the fact that how Shard is doing what he's doing. Somebody else said it today, like, she gonna take the phone county.
All right, let me go ahead and play this for you guys from this morning, and we're gonna talk about it. This is from this morning.
Okay. Good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters, but I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I never wanted to testify.
Okay. The first, well, right, want to.
You said I
is
never
maybe the
wanted to
wrong
testify.
term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no then, if you don't know whether.
I was talking to Melanie, but.
Melnick?
Yes.
Okay. Didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred. I believe that Ms. Bumpus,
I know she was stand-in. And
she was stand-in, and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
yeah, I know she was.
There was nothing about Mr. Melnick to my knowledge.
Okay, maybe
There was. Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his,
well, choose not to testify.
Right. Or if he chose to testify, according to Ms. Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case.
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify, what?
Huh?
So if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial?
Yes.
Not the other people.
Not the other people.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
All right, now we're going to go to the second part of this.
So, I don't know who I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things.
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person if we can have him here in person? That way, if he does have questions as anything's going along, and we're not going to take testimony, I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He should be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. Yeah. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
yeah,
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom.
Mm-hmm.
And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just here.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have
When do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed. Okay.
All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, you know, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection.
It was just the timing of it.
So would you rather I do it Friday? I mean, I don't understand what it is you want me to do.
It was a preference, but I'm going to, of course, defer to the court. It's just, you know, as I work through everything that I know has taken place, I'm just trying to make certain that, you know, the interests of everybody are protected.
Okay, I'm
not trying to create a.
no, I understand. And I mean, I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. You know, I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay. So Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway. It's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay. All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay, is there a screen where he can actually see Mr. Melnick over there somewhere? Okay, thank you. All right. Let's go ahead and get Mr. Copeland in. All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is.
So I ain't got to wait till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick any more about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied
I
and
know,
lied and lied.
I know. And
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do that.
Can I give you an example for what they told me?
Yeah, yes, and then I'll see whether that's
You're
what I
gonna
think or not.
like-
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't have
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe. And they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I am not getting on the stand?
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning.
And how I wake up.
You're free to go for now.
It depends how I wake up.
All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right, thank you. Appreciate it.
Okay, he said it depends on how he feels when he wake up. Pastor. What's your
That's my new line. That's gonna be in my brain cell for the next 2 weeks. I'm telling everybody. It depends on how I wake up.
I wake up. I tell you not, I will plead the fifth or not.
Here's my. She is so in a rush. Like when you look at her, like look how she be so. Oh, I want to grab the mic real quick. I just got to say something. I think she got a slight touch of ADHD. Yeah, I think she got a slight touch of ADHD because she just be like, oh, and then like she is so. This case, why y'all just don't throw this case away? Like the defense and the DA don't get along, none of them. Like nobody, and I could not be in Fannie Willis' position because it's like playing poker right now. It's really like playing poker. All right, everybody is heated at the district person, and we get you, Fannie. Okay, if you watch it and you like, all right, I got a dog in the courtroom. Okay, but even the dog, okay, is gonna have to get some water and tie out. I'm hoping Miss Hilton is about to go do something else because clearly, like, she don't care about Hilton. She don't. I don't know about Melnick. I don't know about how long they've been. I mean, not Melnick, the other ones, Brown and them. But she don't really care too much about Hilton. She commands the courtroom. She's still trying to command the courtroom. And the judge, I'm happy. That's the goodest thing that I've seen.
Okay, Pastor, I wanted to give the people some insight of what happened after he got off the stand the second time. You know, the investigator was trying to rush behind him, to get behind him. Hey, hold on a second, Kenny up. Was trying to rush behind him, and he was speeding out of there, and so he didn't want them near him. So he just dodged out of there. They were trying to chase him, basically. Hey, Henny Hen.
Hi, Miss Sylvia. Hi, chat. Hi, mods. Hi. I don't know there with us. Pastor.
Hey.
How you guys doing today?
We're fine. What would you like to say, Henny, about this?
Well, I got a question.
Mm-hmm.
Okay, we have rights as people. What I'm not understanding is being the coercion, all the stuff they did to Woody. They lied to him. They could have got him in trouble just from his first testimony. How is it that it's like he has no rights?
And he's free. And he's not even in jail.
Yeah, but it's still, I mean, I feel like after all they did to him, there should be a line drawn. You know what I mean? Like, okay, if you don't choose to testify, we won't hold you in contempt because, I mean, the state just can do whatever to you and it's okay.
My thing is he had an attorney. Y'all didn't call the attorney before y'all did that immunity thing. So you gave him something he didn't even understand the law on.
Right. They violated so many of his rights and they're still putting him back in that position. I just don't understand that.
And then, Miss Sylvia, what's really bothers me today, what boiled me under my skin, why does she constantly keep getting up here with this, he is in fear of his life? I think the whole nation have seen, okay, that I don't think that Woody's in fear of his life or anybody in that courtroom, like that judge said, of doing anything to him. Not unless somebody can vouch and say he rolling around with like 8 bodyguards, because Woody been everywhere.
No, I think there was a part where Woody said he wasn't afraid.
Yeah, he did. That's what I'm saying. But she keeps going off of that notion. Like when she got up there, and I'm happy the judge told her, like, listen, at some point, He gonna have to get on this stand. That's what Glanville would have had done. So y'all trying to say y'all had this ex parte meeting, kind of like Max Shaw's putting in his motions, because quote unquote, okay, it was about the fear of his life, but y'all still not putting the facts. And he have not even said that he's afraid of his life. So why you keep putting this on record to make them to make all of them look bad? That's crazy. The judge need to shut that portion down, and I hope she did today.
I mean, oops, sorry. Go ahead.
Oh, go ahead, honey.
I think that Whitaker is trying to be fair, but I think so much damage has been done. I don't know how it could be rectified. I mean, it's like the state does something wrong and they just get like a pat on the back or something. That's what it seems like to me. It's just not fair. As individuals, we have rights as people, as human beings. But it's like Woody has no rights.
Yeah, but you know what? Some of the stuff that Steele wrote in that motion today, and then what Chart wrote, and she still has not ruled on Weinstein. She's waiting for the state to respond and hear the kind of response they give, and this is going to be the deciding factor, y'all.
And he come right on the stand and he said that they told him that the only thing that he'll get in trouble for is pleading the fifth and saying he he unalived Donovan Thomas.
Yep, he said it.
Yeah, he did.
And I noticed the judge just bypassed that part. She focused on the pleading the fifth.
Yeah, she did. I noticed she never brought that back up again.
I don't think she wants the same thing that happened with Judge Glanville. I don't think she wants, because Woody didn't already been in front of her. She don't want to send that man to jail. I'm happy that because Judge Glanville didn't take this tone, okay, or this rhetoric, and she broke it down to the T. Maybe it's her voice tone. Okay, she broke it down to the T. Her mannerism towards, and I like her mannerism towards everyone right now. Okay?
Yeah, she allows people to express themselves, allow them to talk, and she's not rushed with them. She let them talk as long as they want to. Okay, hold on a sec. I got other people trying to get in. Sorry, guys, I wasn't looking at my computer. Sorry, I wasn't looking at my computer.
It's
all right,
okay.
Other people up here. So we're gonna go with Deanna, then we're gonna do it in press, and then we're gonna put you on, Tracy. Go ahead, Deanna.
Hey, everybody.
Hey.
Okay, so I was messaging saying I had a theory. Okay, so remember when Steele was saying everything that was in the ex parte, and he was like, they mentioned about what he said was somebody that wasn't in court that possibly killed Nut.
Mm-hmm.
I think it's still Brady that wasn't discussed yesterday or mentioned, because when she brought up like another person being in the car, and that's who they did the like phone analysis on now. I think there was some truth to what Woody said, and I'm mad that it's not. I don't know if they paid attention. It's not in Steele's motion, but I thought he would have brought it up. Like this is possibly what Woody was saying happened in the ex parte, but nobody brought it up when they spoke about what possibly was taking place in the ex parte and what the private conversation was.
That was a different crime they were talking about with that other guy.
So which car they saying he was in? What crime?
This is a different crime that they were talking about, supposedly with two cars.
I thought they were talking about that. Okay, never mind. Bad theory.
Remember Zachary was in there in the car and all that?
Yes.
Okay, no, I think she's referring to the June 7th ex parte where Woody said about not the June 7th, the Friday.
Yeah.
Where he said something about the
one where he said there was a person that's not even held in being held.
Yeah.
I wonder if that's the same guy.
Was it an Intrepid? I don't know what kind of car it was. He said he knew something about that car. It was something with the I.
Infinity.
Infinity. There you go.
Okay. Okay. Now I know what you're talking about, Deanna. Okay. Never mind.
But I'm just wondering if that's the same guy that he was talking about, if there was some truth to it. But I don't think she's gonna allow anything else about that meeting to be brought back up.
It's gonna be brought back up because the Steele and Char did a motion on it.
But did they put that in there, like him alluding to that? Well, I don't remember hearing it when it was read.
No, they didn't put that in there.
Well, hopefully they watch your video tonight, so they can do another motion.
All right, Empress.
Hello. Okay.
Welcome back.
So I don't think anybody's talking about between the motion that's still put in, as well as the evidence that was brought in. I personally believe, and it may sound a bit much of myself, but I can read energy. And from the energy that I'm reading, when it comes to the judge, she sees directly through love. She sees the inconsistencies. She sees the coercion.
Tracy, mute yourself. You bring him back.
Yeah. So the judge sees the coercion. The judge sees Miss Love and the way that she's running her show. I think what's happening is she's building is the wrong word to use, but she's putting everything together so that when it does come out, that I believe it will either be a mistrial or dismissal. And I believe that she just wants to see for herself, because Grant, she just came in with the last couple of weeks, right? So as she said out of her own mouth, she really doesn't know what that going on with the case. She thinks it is what it is, but as more things seem to come in, like when she said, dang, still, y'all give me information at the end of the day with these bombshells. And I think they do that because that's the way kind of Glenville had been running everything. So when they do it at the end of the day, and now it's 5 o'clock, there's only so much more that she can say. So with the information that came in today about the phone calls, I feel like she's like, wait, what? With these phone numbers and the pinging and the towers and the state trying to introduce this evidence. We saw the late evidence being introduced in that Alec Baldwin case and how that ended, right? So I feel like with now we know that Woody on Monday is only going to come in and, however he feels when he wakes up, right? And the judge said out of her own mouth several times today that, if he doesn't testify, then the case is pretty much over. And I feel like that's what we were seeing Love looking so flustered today, because she knows, like I said in the chat, I don't think that she thought that Melnick and Woody would make their decision today with if he's going to testify, not as far as both being there hearing, the information or whatnot. I feel like she is going to. It depends, really. I feel like it really depends on what happens tomorrow with information that's still brought up at the end of today's court case. So I'm just waiting to see, like everybody else. It's very interesting. I know a lot of people are saying that they don't think she's going to declare a mistrial, but I feel like she is. I feel like they don't understand the giggle. The giggling, I feel like when the judge giggles, is she's like, what a freaking mess this is.
Yes,
what did I get myself into? People think giggling is for some other reasons, and I understand it's people's life on the line, but when you are given an assignment, because she was given this case, she looking at this like, what in all green earth is on my plate right now? And every time Love says so, she just start cracking up.
Yeah, it's the mess. I agree with this. The mess that she sees. Instead of getting angry, she laughs at it.
Mm-hmm.
Okay, Tracy, it's your turn now.
Hey, Miss Sylvia, how you doing? How's everybody doing?
Good.
Yeah, I think first of all, Monday, I think Woody gonna testify because he ain't did no jumper, Vlad. He ain't finished with his runs. And when she said February or March of next year, that kind of shook him, I think. If she would just not gave a date of when this trial gonna be through, we might be okay. But I think he's going to testify. But hopefully, within those motions, he can understand that maybe this case be blown anyway. And another thing that they need to stop doing is mentioning Glanville in these motions. They need to figure out a way to do it without putting his name in it, because that's where they lose her when they mention his name. Because you could see she does everything. You see what now was Glanville in office? No, okay. She'll listen to the story after you mentioned Glanville ain't nowhere around. So they need to figure out what to do without mentioning Glanville's name. And Love or Hilton, in her mind, one of them got to be a casualty of this war. One of them got to go to protect Glanville, I believe. That's just my theory. One of those, that's what she's pressing right now, and that's what she wants them to get on right now. One of them gonna have to go, and I see Love is throwing Hilton up under the bus.
Tracy, I agree.
Yes.
You noticed that too. She's throwing it under the bus. Hey, Renee. Let's let Renee have a say in this. Mute yourself, Trace, okay?
Okay.
Good evening, everyone. I gotta go back for one and catch what the last minute was. I was actually heading out to an appointment. So what Tracy was just talking about, I gotta go check that out. Do you think, Sylvia, this is does this put you in the mind of what the judge is doing, like leaving little breadcrumbs where she's saying, it seems like the release of the transcript, it seems like, okay, well, why did you really release that? You know, I get you're being transparent, but I feel like at the same time, it's like she's dropping breadcrumbs. And I agree also with Tracy. I think they should leave Glanville out of it. Focus on the DA. Focus on the DA. Leave him out of it because she's not going to go against her colleague. But and Shar, I liked his motion. I think he should have left out "we're winning." You know, just give her meat and potatoes because all of this is meat and potatoes. And
But they are winning.
right. But
even though John don't believe it, John over here don't believe it, but they are winning, John.
But we shouldn't be arrogant. You know, we don't grovel over our opponents. You know, so if you're winning, know that, keep that abreast. You know, and besides, you don't let your left hand know what your right hand doing. Don't get so arrogant where you may lose track of always staying on the up and up. You stay sharp. But that's all I wanted to say. Thank you for continuing your hard work. I'm sure. Well, I know you blessed. You blessed. You got so many people watching you. So thank you for all you do, Sylvia.
Thank you, Renee. All right. Anybody else wanted to say something? Henny? I know Pastor got something to say. You know, he always got something to say.
Can I say something, Miss Sylvia? Do you
Sure.
Is there anything like after this is over? Can Woody or Young Thug and them sue the state?
I really don't know. That's not a question for me. That's a judge's. That's a lawyer question, not Sylvia question. I don't have a clue.
So many of their rights were violated. I just don't understand
Yeah,
how.
ask the lawyer on that one, not Sylvia. Sylvia's not a lawyer.
Well, can you ask the lawyers?
I can ask.
Okay. And then let us know.
I'll definitely ask that.
Thank you.
Oh, you're welcome.
And you know you're a blessing, and I appreciate everything you do.
I appreciate you too.
Bye-bye.
All right.
In the bushes.
All right. Mr. 444 Smile, come on up. Come on up, 444 Smile. Pastor, what are you still doing up here? Everybody else left. You still up here.
And Sarah, I ain't even gonna lie to you. I'm cleaning up my desk and just listening.
Oh, okay. 444 Smile, come on up. Next batch. Where are you guys? You know, Horados, Ellis, your thing is locked. It says device is not connecting. All right, I go 444 Smile. Oh, there you go. Hey.
You talking to me?
Yes, I was talking to you.
Hey, Miss Sylvia.
How you doing?
I'm fine. Thank you so much for everything you do. Boots on the ground. You the bomb. You the bomb. And to the mods, you all are just phenomenal. For real. You really are. The way you hold the room down.
Hey, don't call. They call them the hall monitors. They are great hall monitors.
Oh, they're hall monitors? Okay, I have to remember that. Hall monitors. But no, what I was going to say is that I have to agree with Impress. a lot of people are saying they don't like the judge and they feel like she's going a certain way rather than the other. We got to first remember she was a lawyer before she was a judge, and I've been paying close attention to her and her body language. The people think, oh, that laugh she does, but she's doing that because I think that she's setting Love and Hilton and them up. She knows what she knows, but she's allowing them to dig their own grave. And I think that's why she kept saying she wanted to start all over with the whole Woody testimony, is because she could see the corruption, but she already knows that all eyes are on this case. They're under hell of, scrutiny. And the last thing she wants is now they're asking for her to recuse herself. And I don't think she handled Woody like a child today. I think she was trying to be as upfront with him as she could, knowing that Melnick is now stepping in and is representing him. So she was just trying to make sure that he understood what his options were. I don't think, and he said to her, he said openly to her, he said, I heard everything you said, but I don't understand nothing you said. When she went back and tried to go back over it in a different kind of way with the whole robbery scenario. And then at that point, it was kind of like the light clicked on for him. But I do think that on Monday, he's going to take the fifth.
You think so?
I do.
Okay.
I do. Okay, I'm done. So somebody else can go ahead.
They go Mr. Pover for a smile. He said he wants 10 minutes. Go ahead. Your 10 minutes starting now, Mr. Pover for a smile.
Based on what I feel.
Okay, you and that muffled phone of yours, sir.
You hear me now? You hear me now?
You need to take the mask off or something because you muffled.
All right, you hear me?
Yeah, we hear you. You still sound muffled. Go ahead, say something now. Hello? Now he muted himself, y'all. He muted himself. You can't hear him? Now he muted himself. You muted.
Hello, you hear me now?
Yeah, we hear you.
Okay, based on what I was saying about Woody is basically, I don't think he should testify because all this investigation centers around him. If he don't testify, most of this stuff don't come in. So I believe if he don't testify and do decide to wait, this case will end fast because that they will ask for dismissal. They need Woody to get most of this.
Okay, his phone's messing up, y'all. His phone is messing up.
I can kind of piggyback off what he's saying because we pretty much are going to say the same thing clearly, if that's cool. Unless you back.
Go ahead.
Okay.
I don't know. You hear me now? I'm back.
Yeah. Okay, he came back.
What I was saying is basically this investigation centers around Woody. So I believe that even if he sit tight, this case should end fast because they need him to get most of this stuff in. And I believe still do not want a mistrial, and I don't think the judge wants this because if Woody do testify, Steele is going to find.
Okay, his phone's acting up again. His phone is acting up again, y'all. Your phone is messing up, sir. You can go out.
You hear me now?
Yeah, we can hear you.
Yeah, I was like, they need him to get most of this stuff in because Steele is going to find a way to bring in that Judge Glanville ex parte meeting, and she want to protect Judge Glanville. So if Woody testifies the way she did, it sounds like she don't even want him to testify, if you really ask me, because she don't trust him. She say he's not credible. So she don't even want him to testify because he may come on here and lie about something. So she don't know what he's going to lie about. So I believe if he sit tight, this case will end and he won't have to stay till March because most of this investigation centers around him. And what she did was she's even given Steele the record. She has making a record for an appeal because she said this is dangerous for the state and both parties because what she's allowing on the record. She's allowing so much on the record, which I think she's going to rule against. But at least she knows she has given Steele what he wants is his record, to where this is going to be dismissed with prejudice by the appellate division, which if he is convicted, he may sit for 6 months to a year, because the appellate division is going to dismiss all of this with prejudice, and she knows she just cleaning it up. That's all she doing to rule against, to protect the record for Steele, which Steele wants. He don't want a mistrial because he wants to cross-examine Woody and show that the state is dirty. He want to expose the state. This is personal for Steele. He wants to expose the state for how dirty they are and how dirty Glanville was. He wants to move forward. If he don't get a mistrial, he wants to expose everybody. This is personal to him. He wants an acquittal, and I feel that's what Steele wants. But he got what he wanted. I think she did 100% job for what she did for the defense. How she even gave Steele a platinum record that the appellate division is going to ship a lot of those records out and say, we don't want this. So in my case, even if Woody don't testify, this case will be dismissed in probably 2 weeks, because now they can't get most of that evidence in, that hearsay stuff we was talking about. They need him. That's why he's the first witness to corroborate before all the other people to bring in the evidence. So I believe that the judge is not going to do a mistrial, but she's forcing the state hand to throw in the towel.
All right. Thank you, sir. Impressed.
Yes, ma'am. Okay. So here's my theory on Woody and the state and all that, right? So Woody, as I've been kind of paying attention to him, we all know he's not scared. We all know all these other things. We all know all that was said by Love simply to pull on the empathy of other people, right? So I feel like Woody is going to go ahead and sit down. He needs to plead the fifth, which will make him sit down, because that will be the contempt. And the sitting down he's not going to be sitting for months and months and months, right? Because from what we understand is that the state's case rests on his testimony, right? Because they can't even come up with the next couple witnesses after him if he don't testify. That's why Love is all discombobulated, right? Because if Woody does not come on that stand, and as the judge already said, everything is already going to be thrown out, and the whole questioning and everything is starting fresh. So everybody talks about how Woody out here doing interviews and things of that nature and all this other stuff, right? So I really feel like right now all he's doing is stacking his bread so that he can sit down. Because when he first came on the stand back in June, he said on his Instagram, he said, I got to sit for a little while. Don't quote me, but this is pretty much what it says. Like, I got to sit for a little while, but I'm take responsibility, whatever. So however long he thought he had to sit down, it's not even that long. And I feel like after he watches all these videos and everything that I know he'll be watching the next couple of days, he'll understand what we're saying by, hey, plead the fifth, take a seat for a couple weeks, because that's all it's going to be. Because if he doesn't take that stand, Love has no case. The case is over. The trial is done. Forget the ex parte, forget all that other stuff. It'll be an acquittal after, maybe a couple of weeks or whatever, even instantly, because sometimes dismissals and all that doesn't take months. Once those facts come out and the law is what the law is, it's dismissed. And it hopefully is dismissed with prejudice so that this doesn't come back around and everybody can move on, because this has been a clown show.
Yeah. All right. I have Renee coming back up. All right, Renee, go ahead on.
Well, just to piggyback off what T was just saying, when things were getting thrown out, I know when I was listening earlier today, things were getting thrown out, or more or less she was agreeing to remove them. Like, some of the stuff that she wanted to put in was so petty, and just it's like a lot of that stuff would have just wasted the jury's time. It was very petty. It had no meaning. I think this judge is doing a very good job, and she makes what should have been done initially before the trial even started. She makes it look so simple. Like, why wasn't this done like at the beginning. So I kudos to the judge. I really like her. I really do. And I'm digging everything. I love her attitude, her rapport with everyone in the courtroom. Like there are no real big eyes or little U's. She seemed very equal and unbiased. So
Yeah.
kudos to the
And
judge.
she gives them a chance to talk. That's what I like about her.
Yeah, she gives everybody a chance to talk. But I mean, when she asks you a question, she kind of remind me a lot of me, but coming from a mom standpoint, like we know what to ask our kids to get the answer that we already know. We just want to see what they're gonna say, or if they just gonna come with it. She does that, and she won't let you try to sidetrack her. Like you can take her around the corner and back, but she's gonna say, "Hey, I asked you about this." I like that part because she keeps you on your feet, and I know she keeps me listening. So again, thank you. Kudos to the judge and kudos to Miss Sylvia. And I'm out.
All right. Okay, guys. Empress, did you want to say anything else?
I did. Okay, last thing. So I just said in the chat. However, it's not covered. It's not real. I love you. I love you, bro.
You there? Empress. Did we lose her?
Hello.
Hey.
Hello. Sorry,
Yeah.
blame the Bluetooth. I don't know what y'all heard, but I'll just start over. That was my Bluetooth. My apologies. Um, so I was saying that outside of the ex parte and with everything that has happened since the ex parte, obviously we know that we people that comprehend and understand, we know that meeting shouldn't have happened. We know that the way it went, whatever, right? But at the end of the day, between everything that happened today, I don't think we have to worry about a lot of the other stuff. That stuff will be taken care of if, they go back, in the future with the appellate's court or whatever needs to happen. But this case itself, this RICO case, after the next couple of days, after tomorrow, and if whatever happens tomorrow goes, according to plan, then Monday. But at the end of the day, I feel like we shouldn't have to worry about the ex parte because clearly no one else is worried about the ex parte. We're still talking about it, but so much has happened since the ex parte. At the end of the day, anything that happened after that ex parte shouldn't even matter, but it does because that testimony with Woody, right? So you have all these other co-defendants on the case that rest on his testimony. And like I said, I think the judge is setting him up for the alley-oop to say, hey, young man, take a seat. I don't think the defense nor anybody else actually only people that want him on the stand is the state. So at the end of the day, with him having to sit down and just saying, okay, this is because these men have been in jail for almost 2 years off of this man's interview and whatever other evidence we have yet to see in the 9 months we've been listening to this case. I feel like if he gets on the stand and says, I don't recall, or is inconsistent, then they're going to bring in the videos, the jail calls, the tapes, all that stuff they want in based upon the fact that he's going to get up there and say, I don't recall, which is why I keep saying he don't say, I don't recall. Like, it sounds great in a typical case. But in this case, where I hope that most of us are rooting for the defendants, he doesn't need to get up there and say, I don't recall. He needs to just plead the fifth or say, I don't want to testify. He goes to sit in jail. Love sits there looking like a crazy, like she be scratching the back of her head, like, oh my God, right? So that's the energy that she's going to be in if he decides to not take the stand. Because if there's no Woody, then she doesn't know who the next person is to come up because Woody was supposed to lay the foundation for everyone else. So the case in general, all the discussions we're having about the ex parte and about the Brady violation, all that, like we already know she didn't even rule on emotions that came in the past couple of days. So there's still stuff for her to rule on. But I think that the more she's starting to hear about this case, the more she does realize the joke of it that it is. And I also feel like the way she explained to Woody about the immunity, I think that, everybody said, okay, well, Melnick should have told him this and that. We kind of see how a couple of them have their incompetent moments. So when we hope that Melnick gives Woody the same explanation that the judge was given to Love and to Steele, I don't think she did that, because when Woody got on the stand today, she didn't explain it in the same manner that she explained it to Love and Steele. And granted, that's not fully her job, but that was also requested by, I think, one of the defense attorneys for her to explain it to him. But I think that was just if he didn't have a lawyer. But the interaction and the energy that I get from Melnick is that him, Woody, and Kayla got a different type of energy going on. I don't know if it's just for the money or just for the fact that he probably needs a lawyer, but I don't think that Melnick is going to explain to Woody exactly how it was explained by the judge. The fact that it's the wrong type of immunity, the fact about the Fed part of the immunity or the lack thereof, the portion about he can't plead the fifth, because I was seeing people say, oh, he can still plead the fifth, but that is what's going to lead to contempt. But that's exactly what he needs to do. So that's all I have to say.
Great. Thank you again. Okay, let's go on to our next folks. Okay, let me just read. Ariel says, I like the way the judge asks questions. She's very direct. Unlike Love, she tries to confuse you. That is why all her witnesses are sounding confused. Okay, great. Thank you so much for the super chat. All right. Invisible Woman, go ahead on.
Hey, Miss Sylvia. Excuse my tone. I wanted to let the chat know that last time I was on here, they was talking about my voice. I have a voice machine in, so I might sound funny. But don't listen to the messenger. Listen to the message. First of all, I want to say, when it comes to Woody, my thing about it is, this was years ago. That young man, he's trying to change his life, for one. And for two, I look at it like this. If he is to get on the stand and he is to get up there, he can say, yeah, I said it. I said all of it. But he also can say, I told a lie. What they gonna do when the defense come across him and he say, I lied? I was lying. He already said I was jealous. He was going through his own thing. Like, and then we haven't heard everybody else witness, every other witness. Everybody else has wrote statements, but people pick and choose who they want. You know what I'm saying? Who they want to pick and choose. That's just how the world is. And I feel like the state did him that way just so the world could look at him. I mean, it's so much division in Atlanta. So it don't make no sense. And it's still unalive and everything going on with the violence with these young kids out here. So, where is this Rico changing? What are they doing? So I was proud of him. He got up there, he told the truth today. The judge, I feel like, for one, she being a judge, I think she fair. I think she got a job to do. And I just feel like this is not gonna last long. So everybody keep praying for Thug now. Because they was all young and they made mistakes. And that's all I wanted to say. Thank you.
You're welcome. Thank you for being up here. Thank you. Angelica, I'm sorry if I said your name wrong.
Hey, Miss Sylvia, it's Angelica. No problem. Hey, chat. I first want to start off saying the state has not been proactive at all. Even with Whitaker, motions haven't been answered. And today, Love clearly didn't have a clue. And Shard was kind of making her look good because he kept stepping in when he should have just let her kept sinking herself.
You muted yourself.
State, can you hear me?
Yeah, I don't know what's going on. You went out. Yeah.
The state is not really putting forth any efforts to to plead their case at this point. All they're doing is calling out what defense is doing, but this is your case. Love was lost today. And I just feel like it's an injustice. It's a lot of time still being wasted, even with Whitaker. Nothing is really being accomplished. We're doing all this hearsay, and I think Harvey said it best. You can't go by transcripts to depict how this trial has been flowing. That judge would actually have to read the facial expressions, the atmosphere in that courtroom, because all of those things do matter. And that's what I wanted to say.
Thank you. Thank you. You're absolutely right on some of the stuff that all the stuff that I agree with you. So, man.
Yeah, it should be technically it should be over. And Whitaker said earlier before getting Copeland on the stand that she was gonna ask if he had been coerced. She just asked him how he was gonna plead. What does that it matters, but what does it really matter?
It's crazy. It's crazy.
But yeah, that's what I wanted to say. Thank you for inviting me in, and thank you, chat.
And let's say your name again. I just want to make sure I say it right. Angelica, right? Angelica.
Yes, Angelica.
Okay, I got it. I'm
I'll
screwing it up again, but at least I got it right now.
Yes, ma'am. No worries. You guys have a great night.
All right, have a good one. Thank you for your input. Have a good one. All right, guys. Anybody else would like to come up before I end for the night? Because we got to get up in the morning.
Let's see if I just got back upstairs. Like I said, don't mind me. I'm packing up because I'm moving.
You moving?
Yeah.
Where you moving to?
I just bought a house, Miss Sylvia. Just bought a house.
Congratulations.
Thank you. Miss Sylvia, may God continue to keep blessing you with abundance, okay, of joy, happiness, prosperity, and even beyond this case. Okay. So thank you, everybody. I just feel as though listening, coming in and out, you're packing a box. I had to kind of go back. I think Woody should take the fifth. Because if y'all still going to allow him to say I don't recall and then start teaching and start the same thing. So it's either or. Okay. Thank you, Green Eggs. But yeah, I think Woody should take the fifth. Go ahead and sit down. It looks like Woody was already prepared for it. I think it showed me a sign today when he was like, "Oh, well, I ain't got to stay into the other ones, finish their particular case." I hope the state get what they got, and anyone that's on here that's on the opposite side, I'm a fair guy. I'm a really fair guy. If Thug and them did something, they did it, or whatever the situation may be, justice needs to be served. Okay, but for right now, at this particular moment and point, for this last past 2 or 3 years, the state have not given us hardly too much a shred of evidence besides hearsay. Besides, y'all had to trick people, okay, to get them to testify. Y'all got to try to impeach people because y'all want to use the evidence that the police and them has got from them because y'all don't have all the original evidence that the first prosecutor had. Today it showed me that a lot because y'all had to do all these redactions and all of that y'all wanted to use. That really showed me a lot on how the justice system is. And Miss Sylvia, like you said, justice is not right, okay? Because if Glanville, and I'm not using Glanville, but if Glanville was still on this bench, I am pretty sure, okay, that half of the things that got redacted today, okay, he would have gave the state their way because he wanted to hear the evidence outright. Okay. Oh, okay. I think that'll go because I want to hear it. I think Glanville was more really interested into hearing this. Maybe he could have did a job, better job down the line of saying, okay, well, mistrial or whatever. But I think with this new judge, I think like some of the other people said, she's giving them time to hang themselves. Like Jay-Z said, I really wish she stopped trying to go after the defense, because the defense really don't go after her. Okay, they say things, but they say them in a nice, professional, calm manner. She wants to try to get them to stop talking because she wants to be the last person to get something else in. You see it with Hilton. Like I said, I can go on, but Miss Gibb, keep doing what you do.
No, go ahead, because I'm doing something for the people.
Oh,
so
okay.
I'll keep talking because I'm trying to get this little collage together for my folks here, okay? Because I promised them these pictures, and I said I'm going to go ahead and do these collages. It's a little special treat for them.
Okay.
So go ahead, keep on talking.
But yeah, she constantly keeps going after Brian Stills and them, and like Brian Stills and them said, like, listen, I don't even want to talk to that person. Like, the judge even said, listen, she like, I have never heard this. Like Brian Steele said, hey, listen, I have never said this about a district attorney. But even the judge is basically saying, I ain't never heard an attorney say this. The judge is understanding that Love is irritating. The mics is basically saying, we tired of hearing Miss Love. To the point where Love got to get up and say, oh, I'll just yell. Okay? Like, when you have this that's on national TV, when you have this that it's not seeming to be right by a jury of their own peers, and we are considered the jury of their own peers, even though that they're in the courtroom. Okay, those are just 12 people that they picked. They are me and you and everyone else that is in this chat room. Okay, and they ain't give us nothing. Okay. And I think that if I was Woody, coming from where I come from, I take that L. I take that L. I sit down for 6 months or whatever, or however this is going to be. Okay, because yes, without him, they really ain't got no case. They really don't really have a case. I wouldn't, if I was Woody, I wouldn't even want to be going through all of that. You questioning me over and over again. Like that's tiresome. Like my man told him last time, it's tiresome. Okay. But no, I would really not want to go through all of that all over again. So I'm hoping that would he do the right thing? Hold on. That's what you just said. A gangster. I did say I'm not no gangster, Randa. I mean, Rainey, I did say I'm not no gangster. I listen, I am a reform I'm a reform father. Foster care youth. Technician, I've changed. I'm a changed man. I'm a God man now. Okay. So I hope that once again this all comes out and Woody do the right thing. And I think the right thing, I'm hoping that Woody is listening, is definitely plead this fifth. Get it off of your back. Okay, because they ain't gonna stop coming. If I was Woody, I would take the fifth because I would rather get this off of my back, knowing that y'all can't charge me. I'm just sitting here. I'm getting idle time. I already know they gonna he probably don't need protected custody, but they're gonna stuff Woody away somewhere nice. Okay, they're gonna stuff him somewhere nice. Okay, because they don't want quote unquote, like Love is saying, for no harm to come to him, just in case he wants to say, oh, I want to testify now. All right. So they're going to put Woody away somewhere nice. Somebody said, I agree. But yeah, I will go ahead and take that fifth. To the state that's loving them. I don't know if y'all are looking and listening, but y'all got to do a better job with handling cases and treating people with dignity. And if y'all have to go to these extents of what we are seeing and what we're hearing, then I think that, and I pray that God, you know what I'm saying, put y'all in a different profession or make y'all see a different way. Because us as the people out here, the jury people that y'all pick, I think a lot of us don't have faith in the justice system anymore. And we're leaning on to people like Miss Sylvia to bring us down. Okay. And I'm so happy that she's doing what she's doing. Because it takes a lot. It takes a lot. So to the state, Woody, to the defense team, y'all continue to keep doing what y'all doing. To anybody else that is looking at this, that is in their situations or want to change their lives, y'all see how the justice system is not playing us fair. And just to think, this is just because it's national highlight. All of the people that don't have lawyers, okay, they got public defenders that they don't even know their clients' names. So I don't want to make this a church sermon, but I hope that it's hitting a lot of people. Because there's a lot of people that's in their situations. Somebody said that I could talk the ears off of whatever it is. Listen, that's what I do. That's why God gives me my blessings. I'm gonna go to bed. I'm gonna go to bed. I'm gonna go to bed. You know. So listen, y'all do what y'all do. And Miss Sylvia, I will join y'all tomorrow. A donkey green and donkey bad. I see. Big glass on here running around. Pastor, you good? We just playing with you. Oh yeah, I know y'all playing with me. I ain't worrying about none of that. I know y'all playing with me. I know how the internet is, but I know how the fam is over here. Okay. Yeah, I know how the fam is over here. The judge means me. Check. Silver. Okay. Pastor don't need yet. We here. I love y'all too. I love y'all too. I love y'all too. Love you too, Green Hands. Gold minded. I know, baby. I know. It's all love. It's all love. Miss Sylvia not going to sleep, y'all. She trying to prepare y'all because I want to see what this is.
Hold on a second.
Yeah. Mrs. Joe, thank you. Thank you. Make sure that y'all go subscribe to Mrs. Sylvia. Hit the like button. I like those numbers that I've been seeing. 1K likes. And y'all better stay tuned in after all of this is gone. Okay? Because we not just going to be, this ain't about just a thug. We stand in. We stand locked in. Because she going to bring us some other stuff. Okay? And God gonna continue to keep blessing her. So yeah, y'all, just when thug matter is over, whether it's over in a couple weeks or not, if she declares a mistrial or not, I want to see some of these same faces. And I know some people gonna fall off or whatever the situation may be, but Miss Sylvia gonna get some more. Somebody said 2 countries to lead. Thank you. Mrs. Love hair looks good today. I'm tired of saying that pink, what you call them. I don't know about y'all. I'm tired of saying that pink blazer. She ain't got no other blazer. I think that's why they going hard. They need some more money so they can get some more outfits. I don't know. I know Hilton is loving not being on this case right now. I hope she's finding an exit strategy of taking an interview somewhere else.
Yeah.
And poor Brown and them. Was Brown and them in the courtroom today, Miss Sylvia?
Brown was here today.
Okay. Exclusive pictures coming up. Stay tuned. That's right, Tall Glass. Exclusive pictures.
Hold on a second. I'm trying to get him.
Hit the like button. Hit the like button. Win past the win. It's coming up. It's coming up. Yes, what's your question? I think, what is it? Caller? What's your question? Anybody to the stage. Caller B. She is not. Take a mistrial. She played into the fence. Face today. And they didn't even realize it. She led their own version of it. Many people Yeah. Yeah. The law is politics. Yeah, that you, Mrs. Joe, you're definitely right. The law is definitely politics. Mrs. Whitaker is trying to
Infamous.
her career, Mrs. Joe. I need Brown video footage. He's still tripping off that footage you had of Brown video, Miss Sylvia. I said they still tripping off that video footage you had of Brown.
I don't know why this thing is not saving.
Pamela says I do not like when it's not great. Now it's all out. Okay. I'm happy. Me and my family do not live in ATL. Who you telling? Yes, indeed. I'm so happy I don't live in ATL. That's why I said earlier today, folks have got to stop voting for folks for all the wrong reasons.
I'm gonna play this music and then do my presentation. I gotta put my what's the name on? Hold on, I gotta put my what's the name on?
All right, everybody. So listen, Miss Sylvia is ready for y'all. Listen, I love y'all. I'm gonna get at y'all tomorrow. Okay, Miss Sylvia, much love.
All right, hon.
Bye-bye.
Bye. Did y'all see it? Sorry. All right, guys. So I don't know what happened. It didn't show the whole thing. Hold on a second, because it's not doing right by me, y'all. Hold on, yeah, it didn't work out right. Hold on. All right, here we go. Hey, Hipster, I didn't know you was back here. Sorry about that.
No problem, sweetie. I just want to know, why are we wasting all this time? Can't we just say, let the guys go home and let the lawyers go home and play with their kids or grandkids? And can't you go home and play with your kids and grandkids? And why are we doing all of this?
To waste time.
Well, it is a waste of time. Not only time is time, but time is also money. They are wasting so much more money.
Yep, you're right about that.
And then now we got Melnick involved more than ever. And God, I don't even know what they're going to do with Woody. And I'm just, I'm scared for him. What is this I'm looking at? Is this a commercial?
That's Mariah.
Oh, okay. Oh, and yeah. Oh, she's so cute.
That's Yak Mom and Mariah.
But isn't she cute as heck?
Mm-hmm.
Look at that smile. But look at your smile. You're cute as heck as well.
Stop it.
You're pretty as well.
Now you tell lies.
No, age isn't a thing. It's you and your personality and your beliefs, and that means more than anything.
Oh, thank you.
But man, yeah, she's cute as heck.
She is a pretty girl.
But I just want this all to be over. This is just gone on, and love Cliff gets so tangled up in whatever she's trying to do because she can't track what she said the time before. Does that make sense?
Yeah, it makes sense. What, you got a fan blowing or something?
What?
You have a fan blowing? I hear something like something blowing on your phone.
Oh, yeah, I got a fan. Sorry, we live in Houston. It's hot as hell.
Oh, okay.
Yes, I got a fan. Sorry. If it's too annoying, I'll go off. But can't live without my fan.
I got you. I understand.
Uh-huh. And I thought I couldn't believe when Judge Whitaker got up to go change the thermostat. I thought, okay, this is ghetto law if the judge is having to go change the thermostat in the courtroom.
It was so, because she had it so cold in there.
Yep, but I can understand she's a woman of a certain age and she has on a freaking black robe. I'd be hot as hell too. I would probably just tell y'all, go find something else to put on.
Mm-hmm.
But the fact that she was going back there and changing the thermostat, I was just laughing. I was rolling. That was funny. Because you would think there would be people, and I'm doing air quotes, people to do those kind of things.
Yes, it is somebody that would do that for her, but I think she just decided to do it herself.
Yeah, she's pretty hands-on. She
is that.
She's a more common sense individual. Does that make sense? What?
I say, yep, I agree.
Yeah, she thinks of things like I would think of things, or you would think of things. Not how can we get out of this? How can we? I don't know. I still don't know how any of this is going to end because this is just such mess. It's just a mess. And my gosh, I had to call all of my people when Woody said, I'll figure it out when I wake up on Monday. It depends on how I feel when I wake up on Monday.
Yep.
As what I'm going to do. I could not get over that. That was hysterical.
Yeah.
But I agree with him.
Hipsy, you know it's time for me to go to bed now, right?
Yeah, I do. And I'm going to let you go to bed. I love you. I pray for you. I pray for you every day.
Thank you, darling. I appreciate you.
And you're out there doing the Lord's work.
Yes. Amen.
Amen. Love. Bye.
Bye. Love you. Okay, guys. I showed you my little treat, and I'm going to go to sleep now. You guys have a great. You guys have a great, wonderful evening. I put my watermark is because folks be trying to take my stuff, so I have to do my watermark. But that is my little pictures for you guys. All righty. I'm going to bed now. Good night, everybody. Did you want me to play it one more time? Y'all want me to play it one more time? Do y'all see it? Play it one more time. Do y'all see the picture? Or can y'all not see it? I don't know why my What time I'm going live tomorrow? I'm going live in the morning at 7. Between 7 and 7:15 I go live. This is Mariah the scientist. She's Jeffrey's. Sylvia, check your apps for payments. What kind of payments? She said, check your apps for payments. What kind of payment am I supposed to have? Let's see. She said, check your app for payments. What is wrong with my phone? What is going on with my phone? Is it because it's on Wi-Fi? No, it's not on Wi-Fi. Come on. See if anybody sent me a blessing. Okay, let's see. Recently? Somebody sent me a blessing recently? Let me say, check my email. I don't see anything there. I don't see anything in the Cash App. Yes, I see something PayPal. Thank you. Who is this? Thank you, Erin. I gave it to Dallas. That's it, y'all. That was it. That was it. Nobody said anything else on nobody said anything else. Nope. All right, I'm about to go to bed. Yeah, I'm going to bed. Good night, everybody. We need 19 more likes to get 1,000. Come on, y'all. Get the 19 likes. Come on. Could we get 19 likes? 19 likes, y'all. $19 likes. Well, I'm going to go to bed. I'll see y'all tomorrow. Good night, everybody. May the Lord. Did you check Zelle? Did I check Zelle? Let's see. Let's see what's going on with Zelle. Let's see Zelle. I didn't see anything in Zelle. Well, I don't see anything in Zelle. I don't see anything. Let's go check the other. Nope, I don't see anything for Zelle. Nope. We need 5 more likes to get a 1,000. Come on, y'all. We need 8 more likes. 4 more likes. Kiki said 4 more likes. We need 4 more likes. We need 4 more likes. Four more likes. It has 1,000. We got it. We got it. Thank you, guys. Appreciate it. That's not my daughter. Thank you guys for the 1,000 likes. Appreciate y'all. But yeah, I'm gonna go to bed now. Thank you guys for everything. Good night. Good night, everybody. Good night. Good night. Good night. Good night. Good night. Good night. Thanks, Marley. Good night, everybody. We gotta go to bed so I can get up and be bright eyes and bushy tail in the morning. So I can be bright eyes and bushy tail so I can get on some people's nerve with my singing in the morning. You guys know I'm gonna be singing, right? Good night. We have 1,000 likes. You guys are sweetheart. Let me look. I gotta show my face. Hold on. Let me move myself out of this thing here. Let me get this. All right. Bye, y'all. May the Lord watch between me and thee while we're absent one from another. Amen. Amen. Good night. Good night, y'all. You know what? I'm gonna wear a sweater dress tomorrow because it was freaking cold up in there. I'm gonna make sure I have like a turtleneck on and that. Sure am. I don't care if anybody talk about me being out in the street with hot sweater dress. I don't care because I'm gonna be freezing in there. Talk to you guys later. Bye. I'm not freezing tomorrow. I'm not freezing. I'm not freezing. Good night, guys. See you later.